Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need, and remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, please rise and let me know who you represent and how much time you are requesting. People v. Gary Jacques. Four and 1 and 4. Jennings v. City of New York. 5 and 2 and 5. T. Cinque is submitted. Derivas v. Esplanade 99. Could be 4 and 2 and 4. Glenmead Trust v. Infinity, G Capital is, of course, 2 appeals. I'll give you 8 and 2 and 8. Thank you. '27th Street property owner v. Carpati.
7 and 2, please.
I'll give you 6 and 2 and 6. People v. Kareem Perry.
Good afternoon, Your Honor. For the appellant, we request 6 and 2. Respondent requests 6, Your Honor.
5 and 2 and 5. Blanca Realty v. New York City Department of Buildings.
Good afternoon, Your Honor. The appellant requests 5 and 2.
5 and 2 and 5. Mejias v. Bosch.
Respondent appellant requests 4.
4 and 2 and 4. Ichipanta v. Eastside Homestead.
The appellant is happy to submit unless Your Honor has a question.
Very well. We'll take it on submission. Thank you. City of New York v. Eisner.
Good afternoon, Your Honor. All respondent will request 5 minutes in
Okay, the other side's not here, I take it.
I don't think
I'll give you 3 minutes. Pacheco v. Catholic Guardian Services.
Your Honor, appellant requests 4 and 2. Respondent requests 4, Your Honor.
4 and 2 and 4. Canales Diaz v. City of New York.
Appellant requests 5 and 2, Your Honor. Respondent 5 minutes.
5 and 2 and 5. Thomas v. Concourse Rehabilitation.
Good afternoon, Your Honor. Scott Thomas, the appellant requests 5 and 2, please.
Good afternoon, Your Honor. Lisa Fleischman for respondent. Respondent requests 5 minutes, please.
5 and 2 and 5. People v. Glenn Poindexter. Submitted. Sherman v. Zampella is submitted. EPAC Technologies v. Interform is submitted. First case up is People v. Gary Jacques. Please.
Good afternoon, Your Honor. Whitney Elliott of the Legal Aid Society for the appellant Gary Jacques. There's no question that the crimes in this, that Mr. Jacques committed horrible crimes that were the basis for his incarceration. But the issue in this case with regard to the acceptance of responsibility points focuses on whether in Mr. Jacques' most recent credible statements, he genuinely...
Is there any indication that he accepted responsibility at any moment before it would have actually affected his probation status or other incarceratory issues?
So the statements accepting responsibility here were in his 2 parole interviews and in his letter to the SORA court.
And he didn't participate in any treatment that was offered to him, correct?
He did not participate in the sex offender counseling and treatment program. But
And doesn't that suggest that he wasn't accepting responsibility, that that was part of what he did?
With respect, no, I don't think it does, Your Honor. And I think as this court recognized in Solomon, for example, it's not necessarily the completion of the SOCDP as such that's relevant to whether a person has accepted responsibility under the guidelines. It's the effect that it has on, for example, the defendant's attitude, whether it's caused them to acknowledge their wrongdoing, and whether it's prompted them to express genuine regret for their offense. And in Mr. Jacques' most recent credible statements, he did exactly that. He acknowledged his guilt for all 3 incidents. He expressed shame.
Counsel, because they're recent, doesn't that tend to veer more towards them being self-serving versus genuine?
I disagree, Your Honor. A couple things. First, there was no finding in the court below about that. But even when he was before the parole board, he said, I think it was in his second interview, he said, look, whether the parole board grants me parole or not, I know no matter what I ever say or do will ever make up for the acts that I committed 27 years ago at that point. Whether I remain in prison or not, I'll have to continue to grow as a person.
You concede that in Haiti, there's no sex offender registration, or nothing effectively the same as that. Is that correct?
We do not concede that.
You don't concede that.
Is that there's nothing in the record one way or the other about that in terms of the release without...
I thought, what about his lawyer below? Did that lawyer concede it, perhaps in error? I may be mistaken.
I don't remember off the top of my head.
You're not conceding it anyway.
No, and our main point is there was no evidence presented about... The only evidence that was presented was that he would be deported to Haiti. And our point here is that with respect to those points is that the guidelines talk about there has to be evidence that the person, quote, will be released with no official supervision. The fact that someone will be deported to Haiti or any other country says nothing about whether that person will be supervised in that country. And there has to be some evidence about whether there will be supervision or not. The mere fact of deportation alone does not establish that.
And you're saying that it was a people's burden to establish that there was not going to be any supervision, right?
Correct, by clear and convincing evidence. Guess I'll...
You have time to rebuttal, counsel. Thank you.
Good afternoon, and may it please the court, Faith Petrolio for the people. Defendant was properly adjudicated a level 3 sexually violent offender in this case. To start, he was properly allocated points under both factors 12 and 14.
Counsel, can you address whether the people met their burden of showing that he would not be supervised upon being deported to Haiti?
Yes, Your Honor. At the SORA hearing, the people presented clear and convincing evidence that defendant would be deported upon his parole from...
No, I understand
Yeah.
that, but
And
what
that-
evidence did you then produce to show that he wouldn't then be supervised?
That evidence showed that defendant would not be supervised after his release from New York custody. This court, as well as the Second Department, have held that evidence of a defendant's deportation demonstrates that they will not be supervised upon their release.
So the deportation in and of itself is evidence of the lack of supervision?
That's correct. Additionally, as the court has already pointed out, counsel below did acknowledge that Haiti does not have a sex offender registry, and also they did not contest the evidence of his impending deportation at the hearing. About his not acceptance of responsibility, defendant repeatedly minimized his conduct, he denied the sexual motivation behind his actions, and he refused to participate in treatment, which shows that he was properly allocated points under factor 12. Just briefly on the downward departure, his arguments are unpreserved, and his crime outweighs any potential mitigation that he could provide. He went on a weeks-long spree, tying women up and raping them at knife point. So he was properly adjudicated in this case as a level 3 sexually violent offender. If there are no questions, we ask that you affirm. Thank you.
Thank you, counsel.
So just one quick point in rebuttal, Your Honor, in terms of what was conceded below. Whether there's a registry or not, I think is not necessarily what matters. The guideline talks about whether it will be released with no official supervision. For example, there could be some kind of official supervision without a registry. So we would just ask the court to enforce that guideline by its terms.
You want to address the Galati factors for a moment? What was not captured in the RAI that you think should be considered?
So I think that the totality of his expressions of remorse, he did complete several programs. He did try to articulate how to the best he could how.
Yeah, the issue is that, or on that particular topic, is that he really didn't start to apologize until he got before the parole board. That's something that's holding me up anyway, a little bit. Anyway, thank you go ahead, finish the thought.
I just wanted to say, when he did apologize, I think if you look at the content of his expressions of remorse, they struck me as genuine and honest.
Thank you, counsel. Thank you both. Jennings v. City of New York.
Good afternoon, Your Honors. May it please the court, Lara Liotti on behalf of the appellant, Hair America Building. We would contend that the denial of summary judgment to our client was improper on 3 grounds. First is that the issue of whether or not the Hair had properly maintained the sidewalk is not the proximate cause of the accident in this case.
But you point to the photos and say that really the damage occurred to the curb, which would be the city's responsibility. I can see that. But
yes.
It looked to me like the damage, which was sort of considerable, was also on the sidewalk. Particularly in photo, you're not going to remember the photo, but there was one photo in particular that one that's a record 336. It seems to show that the crack goes into the sidewalk.
We would acknowledge that that is depicted. However, the area is under the control of the city. They were the ones who made the subsequent remedial measures. They had notice of this condition approximately 5 months before the plaintiff's accident. Nothing was done. Nothing was sent to Hayer to take care of it, a notice of violation. And then after the plaintiff's accident, the city was the one who made the repairs. No invoice, nothing else was sent to Hayer to reimburse the city for the repairs that were done. And I would also point out to the court that the photographs of where the plaintiff was walking on the sidewalk prior to falling in the street, there was
Counsel,
no
I'm sorry to go back to your last point. It seems like repair is a sign, it can be evidence of control.
Yes.
And that's relevant, but isn't that something for a jury? It's not like a matter of law that they say that means that the city is necessarily on the hook for the damage to the sidewalk.
Well, in this case, we would say that it is dispositive because the looking at the timeline of from when the issue was reported to the city and from the time plaintiff's accident and when it fell, that's the issue of the case. But it's clear there was no communication from the city to Hayer about either you need to take care of this, you're issuing a violation, you need to make this repair, or we've done that. Everything, the totality of everything demonstrates that this condition was under the control of the city. I would also just like to further note that I've already covered that this is a condition that's under the control of the city, but also that there is the speculative nature of the plaintiff's argument. You have a hole that he says, oh, I'm certain that this came from this area 35 feet, which is what his estimation was, 35 feet up from where he fell. The time that he first saw it.
Does it matter that this was like his regular route to Penn Station to get home? Like, he walked this route a bunch of times, and he said he saw, the chunk of concrete a bunch of times.
We would say that that is relevant because you're on notice that if you're saying that you've seen this and you know that it's come from this area. And I would also note that, again, 35 feet, the first time he saw it in the crosswalk up at the corner, and somehow it's magically rolled all the way back down the block where he ultimately fell. I mean, this isn't a tumbleweed, we're talking about a slab of concrete. But it is, you're on notice that you're saying you're seeing this multiple times, you would know that this is there and to be on the lookout. Thank you, Your Honors.
Thank you, counsel. You have time, rebuttal.
Good afternoon, Your Honors. May it please the court. I'd just like to start by pointing out that receiving a notice of violation is not required to trigger your obligation to maintain your sidewalk in good condition. That's, the fact that they may not have received a notice of violation doesn't relieve them of their obligation.
Yeah, I didn't understand her to be arguing that. I just thought, yeah, go ahead.
It may more go to the control point, but the control point is there's no question.
I thought the argument really was that the city didn't bill her client for that, which they would have had the right to do if it was the responsibility.
Well, the maintenance is a responsibility under statute. In terms of, I think what they're trying to argue there is that the city didn't think it had anything to do with the sidewalk because they didn't build them, and I don't know that you can draw that conclusion from that. I mean, I don't think, the city having issued a violation or attempting to build them is not a prerequisite for a finding that they might be liable. And you can think of the inverse situation. I'm sure if they had received a notice of violation or a bill, they would not be conceding that that necessarily proved that they were negligent. I mean, it's a factor for a jury to consider, sure, if they're trying to find out who's responsible for this or how to apportion the responsibility. But we're here on a denial of a motion for summary judgment, and for them to prevail on a motion for summary judgment, they had to establish as a matter of law that the defect was exclusively from the curb, and they haven't done that. As Your Honor pointed out in the pictures, and I think there's even a sort of better color one at page 514 of the record, the missing portion clearly extends well beyond the sort of small area of the curb into the sidewalk flag. It's a very substantial.
What about counsel's point that Mr. Jennings is not qualified to say that this chunk of concrete matches exactly the void of concrete that is on the sidewalk up the street?
I think this goes to its testimony that a jury could weigh and decide to consider or not consider in whatever weight they want to give it. I mean, this isn't, they're trying to characterize it as pure speculation, but this is someone who has walked this route before, who has noticed this, who observed it right after he fell, who took contemporaneous photographs right after it fell. And they seem to be sort of advocating for some sort of standard that you almost had to do, like, take samples of it and confirm that the samples match from each one, or carry it over and put it in and make sure that it matched perfectly. And they're certainly entitled to make those arguments to try to discredit the plaintiff's testimony on this point, but it does not establish as a matter of law that they're entitled to summary judgment.
Thank you, counsel.
Thank you, Your Honor.
With respect to the notice of violation and not being required to do that, or if that's evidence that it was something that was with the responsibility of Hayer, I would also note that the corrective action plan, which details both the notice that this condition existed, but also what was done, does specifically indicate that the city has the right to and will seek redress from the property owner. But which did not happen here. But again, I would just like to reiterate that this is the condition where the plaintiff fell was strictly within the confines of the street. He stepped into the street and fell. The area where he fell on the sidewalk was not at issue, which is usually when, again, administrative law comes in with the sidewalk law. That's not applicable here. What the Hayer did or did not do with respect to the sidewalk is not an issue, and we would just say that, again, it is speculative, because why is there was a hole, that's convenient. Well, was there a hole on the other side of your sidewalk or down the block? If you're able to have the the concrete moved 35 feet one way, why can't something from another block have come up? So we would say that the plaintiff's testimony is speculative, particularly between his 50H hearing and his deposition. There's no affirmation or affidavit from the plaintiff saying, this is how I know that this is from this hole, this is how I know that it matched up. He would guesstimate during his deposition, and therefore the condition, the proximate cause of the accident was not Hayer's maintenance or repair of the sidewalk.
Thank you, counsel. Thank you both.
Thank you, Your Honors, appreciate it.
Diaz de Rivas v. Esplanade.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. Before we get to the merits, there's a big procedural issue here, and in this regard, the trial court used the wrong standard. If you look at page 4 of the record, they did not apply the 50-15 standard. What they did was they said nothing has changed from the prior.
Yeah, we read the two orders.
Right.
So the first order said that, or he said in the second order that he had decided the case on the
Right.
merits in
Correct.
the first order,
In the
but then that's undercut by the fact that that was on default.
Correct. So the April 17th order was on quintessential default, no opposition, and so they couldn't have decided on the full merits, even if they established the prima facie case. They didn't shift the burden to see if we raised any issues of fact to defeat summary judgment. But if you look at page 4, so not only did they use the wrong standard, they did not address reasonable excuse. There's not one word reasonable excuse doesn't exist, right? So they didn't address reasonable excuse. This court has been critical of trial courts that don't articulate any reason for their denial or granting of a motion. They didn't address reasonable excuse. Our position in support of vacator was that the plaintiff's counsel established a reasonable excuse. He mistakenly thought that the second adjournment, which by the way was on consent of the defendant, was accepted by the court because it wasn't rejected. Not the best argument, actually, as this court said in Mejia, but still notwithstanding, it's a reasonable law office failure. It's a one-time procedural error. It wasn't willful, and
Were there any other instances of the law office failure or the like in this case on plaintiff's side of the ledger?
there wasn't. There was just that one, and plaintiff timely moved to vacate within a month of notice of entry. So our position was if the trial court didn't get to reasonable excuse, but the excuse was reasonable. With regard to the merits, as we know, the standard on establishing vacator under 5015A1 is less stringent than defeating summary judgment under 3212. On this record, if the court used a summary judgment standard that was wrong, on this record, I'm not going to stand here and say there isn't some evidence that these two companies were that they were closely related or had some type of relationship. Obviously, they did. However, the burden that we have to show that there was a potentially meritorious opposition.
So the result then, if we agree with you, is that we should remand it to the trial court to look at the merits and see if you have a meritorious claim.
That's correct. And under Williams against the City of New York, this court did just that. The trial court granted vacator. The trial court granted defendant summary judgment. This court reversed, reversed the grant of summary judgment, remanded back to the trial court for plaintiff to put in opposition papers and to determine on the merits, after plaintiff had an opportunity to address the issue on the merits in the opposition papers. So with regard to the issue of alter ego, I can always bring this up and reply if my time goes out, but I just think there are several things that point in the direction that there's a question of fact as to whether they were alter ego. The first one is there's a management agreement whereby Esplanade 99 entered into a management agreement, not with Hotel 99, but with two individuals, Oved and Scharf, for a fee to manage their property. In addition, the the Hotel 99 and the defendant were formed for different purposes. One owns the property, one manages the property. This case in Figueroa is a paint store case. It's in my brief. This court held that just because one party owns it and another party runs it doesn't establish ipso facto alter ego. Should I pick it up on reply? Or
Please,
keep
finish
going?
the thought, yeah.
That was my thought on that.
Okay, well, you'll have some time to rebuttal.
Okay, thank you.
Good afternoon, Your Honors. Robert Von Hagen from Molad, Spitz, and DeSantis for the respondent. An excuse is the reason why you did something wrong. It's the reason why you made a mistake. You can't use the mistake that you made as the reason for having done it. That's circular reasoning. Here, the plaintiff uploaded an incorrect stipulation that was unsigned.
Your argument, it seems to me, excusable defaults often are exactly like this, that somebody made a mistake, and that's their excusable default. I don't understand why this is different from the kinds of excusable defaults that we approve all the time.
The excuse needs to be some external agency that gives a reason for why you violated the law. The
The
uniform
law
rules.
office failure is, by its terms, a mistake somebody made in running their law office.
That's
Why
correct, but you
isn't
can't.
that, excuse me,
I'm sorry, Your Honor.
we often find that that constitutes a meritorious, an excusable default. Why shouldn't that apply here?
Because you can't use the law office failure itself as the excuse for having done it. There's no externality. There's no other force here.
We do that all the time.
But, Your Honor, it's against the uniform rules to make assumptions. An e-filing confirmation is not judicial approval of an application for adjournment. If that were the case, I could get my consent from any adversary in the world. It would be absurd for me to tell Your Honor.
I know that there was the screw-up, but didn't both sides agree to the stipulation?
That deprives them of any argument that this was somehow the fault of the defendant.
No,
This
I'm
was
not saying that.
entirely
I'm just saying that, you know, okay, I think it's right. It was a law office failure. But, you know, they had every reason to think that the stipulation would be approved by the court. They just filed it incorrectly, so they didn't get it so ordered by the court.
Your Honor, there's still no answer to the question as to why the plaintiff did not timely oppose the motion. The stipulation from the previous adjournment made their opposition due by April 5th. They didn't seek an adjournment until April 11th, which was after their deadline to file opposition for summary judgment under CPLR 2214B. They had already
And after
defaulted.
that, they reached the stipulation?
I'm sorry, Your Honor?
And after that point, they made the stipulation to adjourn?
No, Your Honor. They uploaded an unsigned stipulation, which is what Judge Schumacher found was procedurally
But
improper.
your client agreed to the stipulation to adjourn it after what you say is an irresponsible default.
And that was never consummated. The fact that we've extended a
But you
professional
signed it.
courtesy.
You signed, your client did sign it.
No, Your
You
Honor.
signed it.
No, they uploaded an unsigned stipulation. The stipulation that's in the record that's signed by my office pertaining to the prior adjournment. And that's what Judge Schumacher found was procedurally defective. It's one thing.
Perhaps we ought to give a little more weight to the law's preference that matters be decided on their merits.
Judge, this goes to the point that the case was somehow not decided on the merits by Judge Schumacher. In their notice of motion to vacate, they also moved to re-argue and submitted the exact materials they
Where in
thought.
the order do we get any determination on the merits? What language?
Well, in the opening
determination on the
paragraph of the order that's appealed from, he says, having decided the case on the merits, and the defendant made a prima facie case. And then later on in the same paragraph, it says that Judge Schumacher considered the merits of their opposition, which was the exhibits they submitted.
And the basis for his determination was what?
Was
Merits?
Well, it was a number of things. In the decretal paragraph, you see that Judge Schumacher did address CPLR 5015. He then addressed motion to renew under 2221.
Talking about the merits portion.
And then the next decretal paragraph is CPLR 3212, where he upheld summary judgment and adhered to his prior decision and considered expressly in the decision, I've looked at the exhibits that have been submitted in the plaintiff's motion, and they would not raise an issue of fact. So for this court to remit the case back to Judge Schumacher so he can re-adhere to his decision after the plaintiff has had a full and fair opportunity to brief the issues, after they filed a note of issue, they had all the discovery they needed, they're making
Is
this.
it re-adhere to his decision or for him to set forth a basis for his decision?
Judge, he did set forth a basis for decision. Judges do it all the time in much less reductive orders, much more reductive orders that are handwritten from the bench, short form orders, things of that nature. Judge Schumacher here issued a decision articulating every single statutory basis the plaintiff moved under and found there were no issues of fact, there was no basis to vacate.
Thank you, counsel. Any other
Thank
questions?
you, Your Honors.
Thanks.
I'll just stick to procedure right now, since that's what we just discussed. But in Mejia against Ramos, this court said, further, and this is in my brief, but it's 113 AD 3rd 429. Further, the belief of plaintiff's counsel that he thought an adjournment had been granted, although not the strongest argument, amounts to law office failure, which is a recognized excuse for vacator of a default. And yes, Your Honor, the plaintiff obtained consent from the defendant before he mistakenly uploaded an unexecuted stipulation, and under the wrong NICEF category. He took ownership for it, he was transparent about it, and that's the reasonable excuse that's been recognized by this court, not only in Mejia, but also in another case in my brief, also Theodore Rowe. So it's Theodore Rowe is 27 AD 3rd 216, where the plaintiff's attorney was under a false assumption that something had been accepted by the court. So our excuse is reasonable. The court never got to it. And if you want me to turn to the merits with regard to Alter Ego, I'm happy to do it. If I rest on my brief and no questions, I can do that. We're asking for you to remand back to the trial court so that they could give plaintiff an opportunity to put in opposition and to determine this case on the full merits under the public policy of the state, for cases not to be decided on technicalities and not to penalize a client for an attorney's mistake. Any further questions? And otherwise, I'll rest on my brief.
Thank you, counsel.
Thank you very
both.
much.
Glenn Mead. Please.
Good afternoon, Your Honors. May it please the Court, Michael Hampson, Ronak Karima Siddiqui for the appellants. This appeal arises from the stunning collapse of a publicly traded mutual fund. A mutual fund is a heavily regulated investment vehicle in which investors are able to invest their retirement funds with the idea that these retirement funds should be one of the most safest investments that is available. However, in this case, investors lost hundreds of millions of dollars because the assets of the mutual funds were fraudulently manipulated and artificially inflated by the investment fund's advisor, Infinity Q Capital Management. Infinity Q Capital Management was the brainchild of David Bonderman, the billion-dollar private equity owner of TPG. Bonderman put two of his most trusted loyal associates in charge of Infinity Q Capital Management, the CEO, Leonard Potter, and the CIO.
Let's talk about each of the defendants individually. Let's talk about Mr. Potter for starters.
Okay.
So how do we know that Mr. Potter was acting within the scope of his agency?
So Mr. Potter was the CEO of Infinity Q Capital Management. Infinity Q Capital Management was the investment advisor to the mutual fund. It was the one who was in charge of conducting all the investment decisions for the mutual fund and valuing the securities that caused all these investor losses. He's the CEO. That was his job, to be the chief executive.
Well, of course, he tried to limit his signing of the statements.
Right. So if I can get to that specifically, because that's, I think, the nub of this case, right? The claims against Mr. Potter, the main claim against Mr. Potter is under Section 11 of the Securities Act of 1933. The Securities Act of 1933 enumerates certain categories of defendants.
Right, and he's a signatory, you say.
He's a signatory under Section...
But he wasn't a mandatory signatory, was he? He's not among the people listed who have to be signatories to such
Correct.
statements.
Defendants argue that he wasn't required to sign under Section 6 of the Securities Act. That is true. That's what they argue.
Does that matter, that he was not among the enumerated categories of people who had to sign them? Does that matter?
It does not matter, because the specific plain statutory language of Section 11A1 says anyone who signs the registration statement. Not anyone who is required to sign the registration statement, anyone who signs the registration statement. And Mr. Potter signed the registration statement. Now, he tried to do so in a limited...
Is there any provision in the statute that permits someone who signs to limit their liability in any way?
Not somebody who signs. There is a provision of the statute, Section 11A4, for what we call certifying experts, who are the auditing firms who issue...
Right, but they're not signatories. I mean,
They
they
don't,
may sign
exactly,
something,
they don't
but
sign, they give a certificate. With respect to signatories, the statute is clear as can be. It says any person who signs is liable under section 11A1.
And counsel, they're liable even though they don't have an obligation to sign.
Correct. But the registration statement is the quintessentially most important document that a public company can file with the SEC when it issues securities to the public. Congress enacted the law to create it in a way to protect investors, and says, if you fall within one of these categories, and if you sign this very important document, you're on the hook. The only defense to that is the one in 11B, which defendants cite the legislative history of and says, well, the legislative history supports our reading of 11A1. That's completely not true. 11B has nothing to do with 11A1.
It's interesting that there are so few cases on this particular topic. You cite Wang, which is analogous, but not entirely on point. I take it there's no new authority you want to bring to our attention that
We
has
haven't
happened
found one
since you wrote
because
your
the
brief?
I beg your pardon. We haven't found one, and I think it's because the language of the statute is so clear. If you sign the registration statement, you're liable. And it's clear as day. And there's no support that defendants cite for the proposition that you can just write language and create what they called a limited scope signatory. That doesn't exist.
Is it well, that just ties in the question I was going to ask you. In your experience, is it unusual in the Section 11 setting for there to be a signatory who is not a mandatory signer that either conditions their execution of the statement or does so with a disclaimer?
There are not, you don't normally see disclaimers in the signatory section.
Purported.
Purported, exactly. But in terms of does it happen, I can't say. Most times when you have a registration statement for a mutual fund, you don't end up with one of the biggest frauds, frankly, that we've seen in modern history, because these are meant to be safe investments.
Counsel, should we turn to your Section 15 claim?
Sure, and I'd specifically like to focus on Mr. Bonderman, Bonderman LP there, because if you find that Potter signed the registration statement and he wasn't acting in his capacity as an agent of InfiniQ Capital Management, the company that he was the CEO of which was the investment advisor to the mutual fund, then the issue is, for Mr. Bonderman under 15, did he have the power to influence and control InfiniQ Capital Management? And the case law that we cited, I think, is pretty clear on this. Mr. Bonderman LP, which was Mr. Bonderman's private trust for holding his wealth, held an interest in InfiniQ Capital Management, and the registration statement itself disclosed that under the Investment Advisor Act of 1940, he's presumed, it's in the registration statement, he is presumed to control InfiniQ Capital Management. Now, counsel points out, well, that's a different standard than Section 15 of the Securities Act, but it's not a different standard when you actually look at the language, and we juxtapose that language in our reply brief, so I won't go over it here unless you want me to, but basically, it's the same standard. It's whether you have the power, the potential power or influence to control the vehicle that is the primary violator. So in that sense, Bonderman LP clearly is. And there's also case law that we cite, again, in both of our reply briefs and our moving brief, that says, if you set up an instrument like this and you put your trusted associates to run it, you're presumed on a motion, you're presumed to have control over that entity. And here in particular, this was a motion to dismiss. And with all due respect to the motion court drew about every inference she possibly could in favor of the moving party to find that there was no control, despite all these things we put in front of the court. And so on the control issue, I think it's pretty clear that Bonderman LP is a control person under 15, and that InfiniQ Capital Management and Mr. Potter are primarily liable under Section 11.
Potter, under Section 15, I mean, what has he got to do with mutual fund? He wouldn't. I mean, how could he be a control person of the mutual fund, which is part of a trust, which is controlled by trustees?
That's a secondary argument on Mr. Potter.
Right.
But yes, so the idea is...
You're making that argument, though, right?
Yes, of course we are, Your Honor. But the trust, right, is the legal entity. It's a multi-series trust. It's, under Delaware law, the only entity that could sue or be sued. It has 19 series, each of them separate mutual funds. We're just talking about one of the 19 series.
Right, yeah.
But he controlled the conduct here just relates to that specific series of that trust.
But doesn't the trust have its own independent board and officers?
It does have its own independent board and officers, but just because there may be de jure control over the trust as a whole, it doesn't mean that they're the only ones who control it. The law is actually quite clear that you can have multiple people control a single entity.
Okay, thank you, counsel. You have time to rebuttal. Please.
Good afternoon, Your Honors. Sean Murphy with Millbank on behalf of respondents. I'd like to focus on Potter because really everything's derivative of that. Like the rest of the house of cards comes crumbling if
But counsel,
Potter's signature.
Is the law not clear? If you sign it under Section 11 as a signature, you're responsible, right?
So yes, there's a Section 11A that says signatories are responsible, but the critical issue is what capacity did you sign in? Can you disclaim responsibility, and did Potter do it here?
Is there any support in the statute or case law for a limitation of liability like the one that Mr. Potter has put his name under?
Yeah, I would say, well, I mean.
What is the support in the statute or case law for that kind of limitation on liability?
So in the statute itself, I would say that as a Your Honor asked whether it was important, whether he was a required signatory under Section 6A of the 33 Act. That's critical, because I do think.
Does the statute say that? That it's critical that if you're not required, then even though you sign it because you're not required, then you don't have any responsibility and you can limit your liability?
I think if you look at the statutory history, the legislative history, and the entire the structure of the statute imposing draconian liability, absolutely it says that.
Does the statute say that, or just the legislative history?
The statute,
Sort of
6A
patched
says,
together.
so 6A says, here's who's required to sign.
Wait, but does the statute actually say what you're purporting it to say? Or are we to glean that from the legislative history?
I think you glean that part from the legislative history, that if you are required to sign, because the backup for the statute was, we want people to be accountable in the wake of the Great Depression. We want people to be accountable for the statements in the registration statement. And here's what it must say.
And I thought it was we want people to be accountable for the statement. So if you sign this statement, you are therefore accountable for what you sign.
That's why it's, to His Honor's question, it's critical if it was 6A. I don't think he could disclaim it if it was required. If you're not, there
Why
are other.
sign it? If he's not required to sign it and he doesn't want liability, why sign it?
Because he could be required to sign, just as auditors are required
He's
to
either
sign.
required or he's not, and I think we've all agreed that he was not a required signatory here, right?
Well, no, but an auditor, if I'm an auditor, Eisner-Ampner was the auditor in this case, I'm not required to put in my opinion, but if they want to rely on my financials, I have to sign the audited financials. They may be incorporated by reference into the registration statement. They may be
That's a
attached.
different provision of the statute that governs.
I'm not sure it is, Your Honor, because it says Section 11A4 says any person who lends their authority to it it is a person by his occupation who gives credence to some portion of the registration statement.
But if
You can't do
Congress,
that
Like
under
an
6A.
expert? So you're saying he's signing it as if you were an expert?
Well, if you look at 11A4, it says a person whose occupation lends support to it. It includes appraisers, experts, auditors, but there's no limitation on it. And
Do you have any authority for someone who is not a recognized expert but is actually a principal of the company for signing in that capacity?
Well, I think there are cases discussing it, but you don't have to qualify. I don't know. I'm not aware of.
Thank you.
I'm not aware of a case holding that.
A direct answer is always good.
Yes.
So,
I
counsel, you're
apologize, Your
saying
Honor.
that I'm just making sure I understand your argument, that under A4, he's a person whose profession gives authority to a statement made by him. That's the category he falls in. Is that what you're saying?
If you were saying, if you were to hold that the 33 Act, Section 11A, requires signatures to certify the whole thing, I would say that's clearly not Potter because he wasn't required. If that extends to any signature, you have to look at the context of the signature. He could qualify under A4 as a person who lends it to him. He could qualify under 11A. Let's say he signed it, Your Honor's point. He signed it, and he qualifies under 11A. The original question, which I never got to finish the answer to, was, is there authority within the statute? I would say yes, because if you look at 11B, any person, including any person who signs it, can disclaim any portion of it before it goes effective. And isn't that exactly what Potter did? He said, I'm disclaiming, I'm not responsible for this, and it says you have to notify the commission.
Well, not exactly,
No.
because that's not a full disclaimer. He was saying, I'm good in terms of opining on IQ commodity or whatever it was, the other one. The Infinity, the small.
The commodity fund, the
Yeah.
subsidiary.
But he said I can opine on that. That was his carve out.
Right, and if you look at
So
section...
he didn't like abjure saying, you know, I'm withdrawing my certification.
No, I know exactly what you're saying, though. He's certified for this commodity fund as opposed to the broader mutual fund. And if you look at 11B, it says any person, not just experts, can say, I'm no longer a director, or I've now discovered something that's...
Isn't that disclaiming the whole statement, not just portions that you
They
pick
can
and choose?
disclaim part of it. In fact, if you look at 11B, look at how many times 11B talks about being able to part of the registration statement. The statute uses part of the registration.
But does 11B contemplate a separate subsequent withdrawal or disclaimer? Not a disclaimer within the underlying Section 11 statement itself.
That's a fair point, Your Honor. It seems to suggest that you put in a registration statement, and then before it goes effective, you say, wait a minute. So that's fair. So if you wanted to do it, Potter would have to sign as a director of the main fund as opposed to a limited, and then put in something advising the commission that he was disclaiming a part of it. But he did that in advance. But certainly the statute contemplates anyone who doesn't want to stand behind a statement can. I don't think they could do it if they were required under Section 6A. That's why I think it's critical.
So given the historical backdrop of the act, wouldn't it be reasonable to assume Congress, if they wanted to limit the plain language of A1, the every person, that they would do so in some express way, even just by simple reference to Section 6A?
Well, I mean, I think 11B is their way, but that's why I think it's important to Your Honor's point about, I don't think a person that's required to sign under 6A could disclaim it and get the registration statement approved. So there's a 30-day holding period. The SEC requires those signatures under 6A, not Potter's. But if Potter was required to sign and he did what he did and said, I disclaim it, the SEC would say, you can't do it.
I asked your friend a similar question. Are you familiar with any case law authority or in your own experience that whether what Potter did here was unusual in the context of a Section 11 statement, this sort of conditional or signature coupled with a disclaimer?
Not specifically, Your Honor, but I would say that signatures appear in registration statements, which has import to people's liability. Auditors is one I mentioned. If someone notarized a signature of one of the directors and they say, I signed the registration statement, I did sign it. But if I signed it and all I did is notarize the signature and say, well, you signed it, I'm sorry. No, I was only authorizing this limited thing, the validity of his signature. He would never say he's liable for portions of the registration statement other than the validity of the signature. Auditors' signatures appear in audited financial statements that appear either attached, incorporated by reference all the time, and they've actually signed something that goes in. And it's the context of the signature that you have to assess whether there's Section A liability or what's the import of it. And I would argue he's more akin to someone under A4 who lends his occupation to it, or someone who disclaimed it under 11B. But back to the original statute, your question about the legislative history, the whole construct was they wanted people to stand behind it. If you don't stand behind it, you shouldn't be held liable. That's just a basic premise.
Counsel, I'm sorry go ahead.
Or sign it. Right? If you don't want to be held liable, don't sign it. Especially since you're not required.
Well, I mean, if you accept that you can't sign in limited capacity, he was willing to stand behind the statements for the commodity fund.
Do you want to talk about section, this is a kind of a sprawling case, and we don't have the time that Justice Crane had to give to you for oral argument, but do you want to talk about section 15 for a moment? I'll give you another
So
minute.
just on section 15, if there's multiple section 15 claims.
Right.
If you look at Potter, the section 15 claim is he controlled Infinity Q, which controlled him in the signature. That's tertiary liability, which you can't really do, right? It's vicarious liability of respondeat superior. So Infinity Q they controlled Potter's signature. He was their agent. And then Potter controlled Infinity Q. So Potter made Infinity Q, made him sign it? Like, that makes no sense. The other control claims are against BFLP and Potter for controlling the fund. And the court made two arguments, both of which were correct. One, they waived any argument that Potter or IQCM controlled the trust. Secondly, they clearly didn't control the trust, and their allegations don't really say they controlled the trust. They argue that they controlled the fund, which isn't even a cognizable entity. It can't be a primary defendant. You have to have a primary defendant to assert control person liability. If the fund can't be liable, which it can't, there's no question about that, there's no violation. They clearly don't control the trust. As you asked my colleague, there's directors and officers of that fund that clearly control it, and those defendants and U.S. Bank, who they also argued controlled the fund, are still defendants in the underlying case. The case is proceeding against them. So they're saying everybody controlled everybody. It just doesn't make any sense, but there's no allegations in the complaint, certainly with respect to controlling the trust or control of the trust with respect to the registration statement. It doesn't matter that they managed the fund's assets. You needed to control them for purposes of the violation.
Thank you, counsel.
Thank you, Your Honor.
So I do want to clear up a few points because that got a bit messy. Auditors do not sign the registration statements. They provide a separate certification that says, we've looked at the financial statements, we believe that they were prepared in accordance with the GAAP.
And when they sign, does it say somewhere that they're signing in their role as auditor?
Yes, but it's not even a signature. It's a certificate. It just says, we certify that based on our review, the financial statements, this one part, have been prepared in accordance with GAAP, right? That's not the signature to the registration statement. The signatures to the registration statements are the people who sign the thing at the back under the name signature, which Potter did. With respect to the 11B argument, I raised that argument in my reply brief because he cited the legislative history that clearly refers to 11B, not 11A1, but they have never made the argument, not below, not in their opposition brief, not until just now, that somehow Potter was not liable because of 11B. 11B speaks to a couple of very clear circumstances that don't apply here. First of all, you have the director, officer, someone else who signs, who resigns between the period that the registration statement is filed with the SEC and it's declared effective, and they go to the SEC and they say, I've resigned. Before you declare this thing effective, please know that I've resigned and so I'm not on the hook for this. That's not what Potter did. Potter was there until the end. The other one is if there's something in the registration statement they discover that was made without their knowledge and they have a concern about it, and again, they have to go to the SEC and say, SEC, this was made without my knowledge. This is 11B2. Therefore, please, I can't be held accountable for this. Again, that's not what Potter did. Potter signed the registration statement as a signatory and said, I want to limit what I'm covering here. But the statute, 11A1, does not allow him to do that. With respect to...
When one invokes 11B, you're disclaiming the entire statement, right? Not just portions thereof, whatever you pick.
Yeah, you're saying, I'm out. This isn't my company anymore. I'm done. So that's not what we're here. The reason I cited that in my opposition brief is because they took the legislative history referring to that and said, oh, this must apply to 11A. I said, no, it doesn't. That's apples and oranges.
If we were to impose liability or reinstate your complaint as to Potter, would we be opening the door to significant liability that wasn't contemplated by Congress? They contemplated significant liability to the mandatory required signers under 6A, would we now be, imposing liability where it wasn't contemplated on someone who signed it in a limited capacity or proposed to sign it in a limited capacity?
No, because Congress was very clear in the language of 11A. It makes no reference to people who are required to sign. It says anyone who signs is liable. And that's the purpose of the law in order to instill confidence in the capital markets and make sure that anyone who puts their signature on this very important document is going to stand behind it and understands the consequences. If I may, I know I'm out of time. Just
20 seconds, counsel.
Thank you. With respect to Mr. Bonderman, there was some, you can, if you find Potter is liable as a primary liability under 11, and therefore Infinity Q is liable under, as respondent superior, as we allege, you don't need to find that Bonderman controlled the trust stuff. All you need to do is find that Bonderman controlled Infinity Q Capital Management, which we think we've demonstrated in the complaint and in our briefs in space. Thank you very much for your time.
Thank you both. Excellent briefing, by the way, counsel, both sides. 27th Street property owner, V. Carpati. Please.
Thank you. May it please the court, counsel. Robert Friedman, Shepard Mullen for appellants. While there are 5 clear errors below, each of which independently merit remand, I want to focus first on the surrender issue. And just to bring us back as to the context of this, the summary judgment motion in which the court below granted was made in July.
I have a procedural question for you first. What can we know? It sounded like the justice below said he was not relying on the surreply, but do you infer that he was somehow, or somehow the information in the surreply bled into his decision in some way?
It had to have, and I'll explain why. The summary judgment motion, 2 reasons. The first and most obvious is the court said that he did in its decision. The docket number, he said he read it.
Yeah, but he also said, I'm not considering it, so it's kind of a contradiction.
He said, I'm not sure I read it. If you look at the actual transcript, he says, I'm not sure I read it, and then in the decision, he said he read it.
Well, he checked the box, so that's the thing, is like, sometimes you check the box, I guess, as a
I'm
trial
not
judge.
sure he checked it. He actually put the docket, but there's a more important reason, substantively.
Not literally check the box. I didn't mean literally check the box.
Sorry.
That's right, go ahead.
He had to have, because the summary judgment motion sought rent as of July of 2024 in the amount of $4 million. Subsequently, the tenants paid over $6 million, $6.1 million. The issue of surrender was not briefed. It was not, there was no discovery, and it was not even part of the summary judgment motion.
Well, so what the trial court did was sort of say, as you know, like, let's just fold this into the damages portion of this trial.
Yeah.
And so why not there? I mean, could you just, I know that your argument is that forecloses from discovery, and it exposes us to attorney's fees, right? That's 2 bad things that happened to your client as a result of considering that issue in a damages-only trial, correct?
There's Article 31 discovery that has never, we have not submitted, because if there's surrender of
No, I know, and I'm
operation of
saying
law-
that that's, a liability to your client. It's going to be, you're not going to be able to do discovery if you proceed the way the justice.
But there's a whole nother issue here. This whole litigation right now is about the acceleration of the rent. If there was a surrender of operation of law, then there is no acceleration of rent. And this court in Riverside, the Court of Appeals in Riverside, and the court in Spinelli specifically said this is an issue of liability. Every department, the first department...
Spinelli's is a strong case for you, but what can we consider as an appeals court? I mean, you talk about surrender as a matter of law or as by order of law. Or,
operation.
Thank you. Because of the changing the locks, and like they let it out for some parties, the space, and they did some other things that indicate that tenancy was over, your client's tenancy was over. But is that in front of us? I mean, that's
the
all
whole,
in the...
that is exactly our point. It is not in front, the only summary judgment issue in front of the court below was payment of $4 million. And the surrender came up 8 days before the hearing in the form of this improper surreply. That's the only way. And then we filed a notice of rejection of that, and that has never been addressed or ruled upon. Your Honor's,
Well,
Your Honor's statement...
wasn't that one? That was also one of the documents that the judge said that he considered in deciding the motion. Your rejection as well.
It was, but there's been no evidentiary development of this.
Yeah.
It's purely allegation. So your point, Your Honor, is exactly what our argument is. This needs to go back with respect to the surrender issue. It has never been briefed. It's not part of their summary judgment motion. It's not part of the record, and there's been no discovery. So there's a big difference between damages and liability, and the courts are clear. Spinelli, the Fourth Department, Bay Estates, we're uniform here. It's not an issue of damages. It's an issue of liability, clearly. And there are so many other errors here below between looking at the wrong agreement with respect to the fraudulent inducement claim, the lease versus the guarantee. There is absolutely no provision in the guarantee. And this is only the guarantee action. It's not the other action.
Right.
This is only the guarantee action with respect to that addresses the validity. And the courts from the White case, from Manufacturers Hanover, unless you have the word enforcement, which was only in the lease, and the court admitted below that he only reviewed the lease, he didn't review the guarantee. You also have him looking at the wrong complaint. There was an amended complaint. We had approximately 15 additional allegations in the amended complaint, and he admitted below that he was only looking at the original complaint. So this is strewn with errors. Your point, Justice Moulton, about it's not before us, it was not before him either. And he effectively granted summary judgment on the surrender issue. And that he just can't do on this record under the law of this, under the clear law of the First Department, of the clear law Court of Appeals, and every other department. It's just basic. Thank you.
Thank you. You have time in rebuttal.
Thank you.
Good afternoon, esteemed panel. Andrew Ergenson, a respondent. Thank you for your time today. I'd like to just first start with the surrender as a matter of law question, only because appellant did. The surrender as a matter of law argument is a complete red herring. The lease specifically states that you cannot have a surrender unless there's a written acceptance of surrender by the landlord, and no conduct of the landlord could be deemed an acceptance of surrender other than a signed writing. Judges on this panel, and we cited at least 4 cases in our brief, that demonstrate that in those circumstances, unless you have a written acceptance of surrender by the landlord, you cannot have this so-called surrender by operation of law. Judge Rodriguez was on the panel in the case of 1140 LLC versus My Studio. In that case, just like here, at least some rent was owed prior to the surrender date, and that was undisputed on this record. So the court was properly granted summary judgment as to liability, and then said, you know, we'll have a hearing on damages. The tenant did exactly what counsel is doing here. He said that there was conduct, some sort of conduct that amounted to a surrender as, as a matter of law. They said he stopped, the landlord stopped issuing invoices, he arranged the move out, all those types of things. But the court, in that case, the First Department, said that Article 25, called no waiver, said that no agreement to accept surrender shall be valid unless in writing, and based on that, the court affirmed the decision below and dismissed the argument that there was some sort of surrender as a matter of law. Here, they do not say that there was a written acceptance of surrender, and that is fatal to their surrender argument. And that's the end of the story.
Counsel, let me just pivot for a second. Is it not true what I said before, that the fact that these issues, whatever remaining issues there are, have been sent to a damages hearing, and so doesn't that mean that they don't get discovery? And that you, your client, is a prevailing party, and therefore they're exposed to attorney's fees? Isn't that two things that are to the detriment of your opponent's clients that result from the way the justice below has choreographed this case?
Well, first of all, there is no right to discovery here because, like I said, the surrender argument fails as a matter of law, so there's no questions of fact to resolve. So that's an irrelevant point. But the reason why surrender was never brought up is because surrender is their defense. We moved for summary judgment. We made a prima facie showing that there was an enforceable guarantee in default way before the alleged surrender, and they opposed not mentioning surrender at all. The only reason we're even talking about surrender is because they submitted an unsworn objection to our supplemental affidavit, basically saying, hey, there may be a surrender. And then in court, they said, hey, there may be a surrender. But they didn't submit any
They have another
evidence.
defense which we actually haven't talked about yet, and probably you should spend a little time on fraudulent inducement, too.
Yes, I'm more than happy to discuss fraudulent inducement. Fraudulent inducement fails for at least 6 reasons, okay? The first reason is that the alleged fraudulent statements, which were the so-called promise that they didn't have to pay rent, even though the lease said they did have to pay rent, happened in 2022. The guarantee was signed, which they seek to render unenforceable, was signed over a decade before that. So as a matter of just, physics, it's impossible for the guarantee to have been fraudulently induced. And the guarantee, it specifically states that the guarantor waives any defense regarding the validity of the underlying lease. And that's enforceable. They don't dispute that's enforceable. And that's what's at play here, because what they're saying is that they were fraudulently induced to sign the Third Amendment to the lease, not the original guarantee. Now, they try to get around that. They say, oh, by the way, the Third Amendment says there was an amendment to the guarantee. But that amendment only applied to the good guy clause. It changed the good guy clause. They also, in that Third Amendment, restated and reaffirmed the guarantee. But even if you take those amendments out, you can throw them in the dustbin, in the trash bin, and it wouldn't make a lick of difference, because the guarantee itself, which couldn't have been fraudulently induced, says that it applies to not only the lease, but any amendments of the lease, regardless of whether or not the tenant had notice of those amendments. So that's just one reason why the fraud claim fails.
If an amendment to the lease was found to be fraudulently induced, that does not matter, is what you're saying, under the guarantee.
That's one.
They're saying, you guys came to us and said you need to fix your, you need to not get in trouble with your mortgage and for the building or whatever mortgage you were applying for, and they said, okay, we'll help you out here and pretend to be your tenant at this rental amount.
Right.
And you said in return, okay, great, do that for 1 year, and then after that you don't have to pay rent. That's sort of roughly what the defendants are saying, I believe.
That's what they allege, but the guarantee waives any defense regarding the enforceability of the lease, and that's found to bar. That's been found to bar claims for fraud.
And that's your argument right there. That kills any fraudulent inducement claim.
That's one of the 6 reasons it gets killed. But even if we went back in time, and even if my client can time travel and fraudulently induce the original guarantee, there are robust disclaimers in that as well. It waives all defenses regarding any act or omission of the landlord, and fraudulent inducement would be an act or omission of the landlord. So the defense would be waived there too. But also importantly, and I'm not sure that this has been covered, the guarantee says that the guarantees, the tenant guarantees the guarantor guarantees the tenant's obligation with the same force and effect as if the guarantors had been a signatory in the lease. Now, the lease also has provisions that disclaim any fraud claim, including a robust merger clause that says that the tenant, where the tenant represented that he was not relying on any oral statements in signing the Third Amendment. It also completely disclaims the alleged fraud because the alleged fraud is you don't have to pay rent, but the lease says you do.
Okay, thank you, counsel. You maybe want to pick up the thread on fraudulent inducement?
Yes, if I could, though, just address quickly, because I'm frankly baffled by one thing I heard, which was that we didn't raise the surrender issue. There was no surrender issue. The summary judgment briefing was in 2020, 2024, a year before, half a year before any surrender. And that's the whole point. It couldn't have been raised. No one raised it. They didn't raise it. We didn't oppose it because it wasn't raised. The surrender happened in the first quarter of this year. And the only way it got to the court effectively granted summary judgment on the whole surrender issue based upon those two, based upon that affirmation.
That's the basis of your claim that the judge had to have read that because he wouldn't have known about it otherwise. He had to have read the surreply.
Whether he was treating it improperly under our law as a damage issue, or he read it and considered it, either one. That's why when I was discussing this with Justice Moulton, said he either had, either way it's error that has to go back because the issue had not been joined. There was no surrender issue in the summary judgment briefing, and it was only raised 8 days before the summary judgment argument. That's not proper, and that needs to go back so we can get discovery for several of the reasons that we discussed. On the fraudulent inducement, you just have to look at the contract. The guarantee has language with respect to absolute and unconditional, which is the same language that the court considered in White. It does not have any language, there is no language in the guarantee with respect to validity, which is in the other cases that the landlord cited, or with respect to inducement. It just is not there. And the court below was actually reading the lease. He was not reading the language.
No, I'm sorry, maybe I'm reading from the wrong section, or I don't know, different case, but doesn't the guarantee say somewhere, the validity and enforceability of this guarantee and the obligations of guarantors hereunder shall not terminate and not be affected or be impaired by reason of the invalidity or unenforceability of the lease? Doesn't it say that?
I'm reading from the guarantee where it expressly waives.
Section 8, I think. I don't know. It's like, this is, yeah. I don't know, counsel. We'll look it up. We'll look it up. But that just undercuts your argument.
And if I can, just to be clear on what the fraud is, I believe it was not stated. They basically said an actual statement before the Third Amendment when we had already submitted a surrender notice, and in order to induce us to withdraw the surrender notice, they said, listen, submit this, we have to pay, this has to include property taxes. We don't know what they were doing with their own lenders, that's up to them. They said the reason this is high, and this is a specific statement of present fact, this includes our property taxes, and that's why, and it's only gonna be for a year. That's what induced it, and that is the fraud. Thank you. Thank you.
Thank you both. People v. Kareem Perry. Please.
Thank you. Good afternoon, and may it please the court. Jacqueline Shelton here for Mr. Kareem Perry. The police cannot manufacture probable cause by repeatedly badgering a purported witness until that witness agrees with the police that the person they already have in custody is the culprit. And that's what happened here. When the police responded to the building, everything that they uncovered after actually cut against probable cause. This is a very fact-specific case.
Counsel, let's talk about the show-up identification. What was the first identification by the female witness?
So the purported show-up, which we do not believe was an identification at all.
So you're not saying that it was an equivocal identification, you're saying that it wasn't an identification at all?
It was not a positive identification. It was an identification procedure using highly suggestive and highly unreliable methods, including a single photo that showed the person's face despite the fact that the only witness that provided a description of the perpetrator described primarily the clothing
Well, it
and
showed
the
the
height.
clothing as well, right? Because if I remember correctly, the witness said, both witnesses that were shown the photos, they both had problems in that the defendant was in different clothing from what the suspect had worn. So it wasn't only a picture of the face.
It's true. The photo showed from about the chest up, so you can see the top of a T-shirt, but it is primarily the face. And so that first, going back to Your Honor's question, that first attempt, while my adversary is hyper-focused on the language it looks like, it has to be considered within context. And this is a case...
Saying that it looks like him, but he has different clothing on, in your argument, is not an identification at all.
It is not a positive identification that supports probable cause. Given everything that we observe that occurred prior, the choice of the language, and this is a case where, thank goodness, the body-worn camera captured what actually occurred here. While the prosecution does cite some cases where, under specific circumstances, using it looks like could be considered an identification or a positive one, in this case, it's very different set of facts. In those cases, there are other indicia of reliability, such as the person actually seeing the perpetrator around the neighborhood before, the method of identification procedure being a reliable one with multiple photos shown, the opportunity to observe, whereas what we have here is a witness who actually doesn't tell, the one who they brought up to do this identification, didn't actually give any descriptors other than agreeing with her son that the person was black. She does say, I didn't see the person at the very beginning. When they ask her, did you see the person's face in the elevator? Visibly, and I would encourage the court to look through the body-worn camera, you see that she doesn't say yes, that she says, shakes her head
So how much
slightly.
time had elapsed from the time that the police officer stopped the defendant in the hallway to the time that they attempted to get the first, that they conducted the first identification procedure with the female?
It was about 12 minutes.
Okay.
And about 52 from the purported incident occurring.
So at that time, when they conducted the first identification procedure with the female, there was not a positive identification, correct?
Correct.
Then they also did an identification procedure with, I'm not sure the relationship, the son, the male witness.
Yes.
And there was, again, not a positive identification, correct?
Correct.
Then 12 minutes, I think 10 minutes elapsed from the subsequent identification procedures where they re-asked her to if she recognized the person in the photo.
Correct.
What effect does that have, that passage of time?
So the passage of time, we argue that he was subject to custodial detention.
When did it
within that
become
12
custodial
minutes.
detention? Within that 10 minutes?
Within, I would say, the first 2 minutes. And that is supported by the court's decision that he was in custody for Fifth Amendment Miranda purposes, because we know lawfully that a determination of custodial detention considers that he was subject to the degree of, I'm sorry, a forcible
Let me take it back
seizure,
a step, counsel.
which curtails, I'm sorry.
With regards to reasonable suspicion,
Yes.
what's your argument with regards to that? Did they have reasonable suspicion?
So I agree with with the defense counsel below that they may have been able to initially stop, but the moment that he was subject to custodial detention, which occurred about 2 minutes in, is when probable cause was required.
What was the event that changed it to custodial?
So there's the two officers, one grabbing of the wrist and one grabbing of the shoulder. The repeated interrogation, knowing, as the hearing court noted below, that a cell phone had been left behind, and explicit incriminating questions about the cell phone, as well as him requesting to leave.
Yeah, Mr. Perry
multiple times.
repetitively said that. He repetitively said that, am I free to go? Am I being
Yes.
detained?
Yes. And so it is at that point we agree, as the hearing court found, that he was subject to custodial detention and that probable cause was required. So just very briefly, the passage of time makes that more clear. If the court disagrees that the detention occurred at that point or the arrest occurred at that point, certainly as that continued time goes on, he was subject to the to a degree of seizure that was equivalent of arrest such that probable cause was required, and the police never had it throughout this encounter.
Thank you, counsel. You have time in rebuttal.
Thank you.
Your Honors, and may it please the court, Anna Nachik for the people. The police officers had reasonable suspicion to stop defendant and place him in an investigation.
Counsel, what with the two identification procedures that I alluded to before, the one first with the female and then with the, I think it was the male first and the female, I'm not sure. But the two where there was something other than a positive identification, whatever you want to call that. What authority did the police have then to continue holding the defendant?
Well, Your Honor, we dispute that those were not, that the female victim did not have a positive ID of the defendant. This court has repeatedly found that looks like language can constitute a positive
She said a little bit more than that, right? She said it kind of looks like him, but it went by so fast, he was not wearing the same clothing. It's completely equivocal.
I believe that is the second identification, Your Honor. The first one, she says, it looks like him, but he changed his clothes. And that...
But it looks like him, he changed his clothes. Are you arguing that that is an unequivocal identification?
Yes, Your Honor, because it's not the type of identification where she's saying, oh, I'm not sure. It was very clear from the photo that he had changed his clothes.
Did the officers view it as an unequivocal identification?
Well, Your Honors, I think the officers, again, their subjective determination of whether or not this is probable cause is not what is controlling here. But I think it's okay that the officers wanted to continue to investigate this. And I want to...
Wait a minute. So that's my point. What's the investigation that they undertook between the time that she made this equivocal statement and I also want to push back on your statement that it's clear he changed his clothes. That's assuming that you got the right guy, right? And that's the whole point of this.
Right.
That's not your determination to make. So we got to look at this objectively. So in terms of once the witness doesn't make what I'm going to say a positive identification, she does not say that's him, right? And the son doesn't say the same thing, that's him. Then 10 minutes go by. What investigation did they undertake? What happened that was different from when they showed them the photographs the first time to when they showed them the photographs the second time?
Well, they do undergo additional investigations.
What is it?
Specifically, they're trying to figure out whether or not this is someone's phone and whether or not it can be connected to the defendant. They're trying to call 911 from the phone.
That has nothing to do vis-a-vis the identification, right? Where did they get there? Did they identify the phone as belonging to the defendant?
Not that night. They did not identify.
Not that night. So it's out with regards to reasonable suspicion or probable cause, correct?
It can't be a part of the calculus.
Right, Your Honor. I was just explaining that there was additional investigatory steps taken during that time.
What were the steps though? Because from watching, because thankfully we do have the body worn camera, right?
We did watch them.
From watching it, the steps that happened were was more pressure for identification. Is this the person? Is this the person? And also trying to get the son to come upstairs and make an identification. What other investigation occurred?
Your Honor, there was no further investigation into, I guess, the identity at that point, but...
Right, there was none to be had because all the police had were the two victims, right? In terms, as far as I understand, and I didn't read it in the record, there were no other potential eyewitnesses. They weren't canvassing for other eyewitnesses. There was none of that. So what it seems to me to be here is you have an identification procedure that didn't go the way you expected, and you retried it. So the question is, how many times can they retry?
Your Honor, I don't think there's a number. Again, our position is that first identification was enough, specifically given, and I want to
let me understand you correctly. So when the eyewitness says it looks like him, but he changed his clothes, it happened so fast. In your view, that's enough for probable cause?
Yes, Your Honor, given all of the other indicia.
What other?
Your Honor, he matches the description. As the judge said below.
He matches the description that he's a black male, 5'5", thin. He's not wearing all black clothing. He's wearing all red clothing. He's not wearing a red bandana. He's wearing a red face mask, which matches the rest of his red clothing. So what is it that you're saying?
I think the red bandana around his neck can easily be the red face mask, which was around his neck. And he was overheard talking about having just got someone and having scared someone.
From 2 floors up, correct?
That's right, Your Honor.
From 2 floors up, and was there any temporal connection? Do we know what he was discussing?
No, Your Honor, but I think it is important that there is a temporal connection between this and when this happens. It's I believe opposing counsel said it was 52 minutes. It's in the
So the
same
officer
building.
identification of the voice that he heard from 2 floors up in your mind is more important than the equivocal identifications made by the 2 witnesses.
Your Honor, I'm not saying it's more important. I'm saying that this is a totality of the circumstances test as to whether or not there were probable cause. All of these things.
So so that I understand you correctly, the totality of circumstances is a description, just plainly the description of a black thin male, right?
About 5'5" and wearing a red face mask, or a red bandana around his neck.
And what else? What other?
I also think that there's the fact that when the police approach him, he gets very nervous. He starts sweating. The officers talk about that. But Your Honor, I'm putting this all.
25 years in prison. Being afraid of police officers may be something that's okay under his circumstances.
Your Honor, and we can take all of these things separately and say this isn't probable cause.
Why don't we do this? How do we ground it in the cases that your adversary indicated were distinguishable, right? So your adversary said that this kind of equivocal identification in other cases had other distinguishable factors. Are there any cases where the factors are the same as what we have here?
I don't think there's anything that's exactly the same. However, I would point out, and I believe it was Williams, but I'm not positive about the case, that in one of the cases, the victim actually at first said, identified the wrong person, and then later on said, oh, that looks like him in a different photo. And that's not what we have here. We have something more than
What were the other circumstances surrounding that identification? So, for example, was a person wearing the same clothing? Was it someone that they had seen in the neighborhood multiple times?
It was also a photographic ID, Your Honor. I don't exactly remember the facts of that case, but I will say that it's, in that case, the victim had at first identified the wrong person. And I don't think we have that here. And I just do want to focus on the fact.
In that case, was that one continuous procedure? In other words, was it they're looking at several photos, maybe miss IDs, and then says, no, it looks like this person, as opposed to you do one procedure, then you come back 10 minutes and you do a second procedure?
It was continuous in that case. I also just want to point out that at the very end of this interaction, after the 25 minutes, and I know we've talked a lot about that, but she does say that she is willing to testify to this under oath. She says, yes, I will testify to that in court. Throughout this entire, and I know we've all watched the video, throughout this entire encounter, she is understandably terrified, very nervous to identify the defendant. That's why she's shown a photograph. So the fact that she's a little hesitant, I think just goes into how terrifying of an encounter this was. And just given that she does say it looks like him and there are other indicia that show probable cause, we ask that this court affirm. And I am happy to address the other issues, but.
Thank you, counsel.
Thank you.
Just a couple of quick points.
Counsel,
Yes.
what about that last point? If she said she was willing to testify, the defendant was the robber, does that give you probable cause, give them probable cause?
No, it doesn't under these circumstances.
That happened well after a number of repeated attempts to get an identification, right?
Yes. And the police actually ask, there's a family friend standing next to her, and he somewhat intercedes and answers the question for her, and it's only after that that she says yes.
Can you distinguish the case cited by your friend, People versus Williams? Is it distinguishable in any way?
Yes, there was actually a separation between the identification procedures in that case. If I'm remembering the case correctly, there was note by the court of the enthusiastic nature of the response of it looks just like him or something along those lines, whereas what matters here is really everything that we have in front of us. It's not about words and just looking at it on a blank canvas. What we have
Your
here
adversary says it's the totality of the circumstances, that there were other indicia of probable cause, right? So the description, how do you argue against that?
So the description is extremely vague. And like I said before, at the very beginning, I don't dispute in my brief, okay, sure, they could have encountered this person, but when there's no positive identification, just the description of a black male, thin build, height, that would allow the police to have, if that carries such import against an equivocal statement by a witness, that would allow the police to arrest many, many, many people. And here, you know, I do think it bears noting that Mr. Perry was, while the people are talking about Ms. Augusto's statements and her state of mind at the time, Mr. Perry was acquitted of everything that relied upon Ms. Augusto and Mr. Robles' statements.
How do you respond to the prosecutor's statement that this was a traumatizing experience for the witness and that maybe her hesitancy had nothing to do with whether she could identify him or not, but she was scared?
Well, I think that looking at all of the circumstances, this is so unreliable because she never expresses an ability to identify anyone at all.
But she also doesn't say it's not him, right?
She doesn't, but it doesn't mean that it doesn't cut against probable cause. And the only additional investigation that occurred, the cell phone investigation that the prosecution relies upon, did not establish Mr. Perry as being remotely involved. In fact, it only cut against probable cause by showing that the person who had left the phone behind was not in any way connected to Mr.
Also,
Perry.
just to clarify, the photo that was shown to the female and the male originally in what I call the first procedure, and then the photo that was shown in the second procedure, same photo?
Same photo 4 times, shown to each of these, Ms. Augusto 4 times, the son at least 1 time, possibly 2.
And your argument regarding the suggestiveness of this procedure is the repeated attempts for an identification?
Repeated attempts, single photo, picture rather than in person. But it's the suggestive nature of showing a single photo again and again and again and again, attempting to get an individual to change their answer, which ultimately, after much persuasion and coercion, she does ultimately, but at that point it was so unreliable that could not have lent itself to probable cause. Thank you.
Thank you, counsel. Thank you both. Blanca Realty, the New York City Department of Buildings.
Good afternoon. May it please the court. Michael P. Lagnato for the appellant, Blanca Realty, LLC. The primary issue here in this case is whether or not a reasonable attempt was made to serve my client with 3 Department of Building violations. It is the appellant's position that no such reasonable attempt was made. The inspector merely asked a tenant, and remember this is a multiple dwelling, it's not a single unit building, on his affidavit of service as a pre-printed statement that he asked the tenant if the owner resided in the apartment. The owner was an LLC. Obviously, an LLC doesn't...
The fact that it's a pre-printed portion of his affidavit of service dispositive?
Not dispositive, no. But it is an indication that that is something that he puts in all of his affidavits.
Or something that is a question that he asks all the time?
Very true. But the answer obviously isn't always the same. And the way that he wrote it made it appear that that would always be the same.
Nothing precludes him from crossing it out when it doesn't apply, right?
I'm sorry?
Nothing precludes him from crossing it out when it doesn't apply.
Of course not. Of course not. Nevertheless, even if it were true, that would be insufficient to be reasonable, according to the appellant. This is, as I said, it's a multiple dwelling. In this particular case, in the lobby itself, there was a big sign that identified the owner of the building. It identified the managing agent. It identified the superintendent. It indicated the superintendent lived there.
Counsel, you don't dispute that the mailing occurred, right? It's just you're saying the nail and mail was not appropriate here.
Well, I don't believe that the proof of mailing was sufficient.
But did you raise that in front of oath, though? That argument?
The issue of jurisdiction and service was raised.
Right. I'm saying that, you know, that subsection of that argument, was that raised before oath?
That, I do not believe that it was, but I believe by raising the I think the case law is pretty clear, by raising the jurisdictional issue, the burden of proof of service rested now with the respondent. It also brings up the issue of whether or not there was proper filing. There is no proof of the filing of the affidavit of service, which is also required. There was in the...
Dispute that it was posted on the front door of the apartment?
No, the posting is not disputed. Only the reasonable attempt and the mailing and the filing with ECB. If you take a look at the purported filing, the proof of that, actually the filing, the date on that document, it predates the date listed on the mailing. So on the ECB, purported ECB filing, it says December 29th. But the purported affidavits of service say, affidavits of mailing, say December 31st. So obviously, the affidavit of mailing could not have been filed prior to it being made.
Maybe we should turn to the merits briefly, counsel. So how does substantial evidence not support the finding that that the apartment had been carved up into 3 different apartments?
Well, it would have to be 3 additional apartments.
Yeah, I mean 3, that's what I properly state.
At best, I believe the hearing testimony was muddled as to how many units there were. If you look at the affidavits, there's an indication that there were only 2 additional locking doors with locking mechanisms. In the hearing, also the hearing officer makes a point of the fact that only 1 partition wall had been added. At best, it's unclear, and therefore it's our position that there's no substantial evidence. It's also, I believe...
The 1 partition wall made 2 rooms, 2 additional rooms, right?
I believe a partition would indicate 1 additional. It would indicate 2 rooms, but only 1 additional.
Okay.
And then I'll rely on our brief for the position with respect to an exemption should have been applicable here, given that this was a first-time violation. And
How long did they take to remedy the situation?
Well, it's unclear as to when the situation was actually remedied because my client didn't have access to the apartment itself. When they found...
How long did it take before your client sent a notification to the tenant?
I believe it was 20 days, Your Honor. Oh, to the tenant? Immediately upon receiving the violation.
Thank you, counsel. You have time in rebuttal.
Thank you very much.
Did you want to say?
Thank you, Your Honors. May it please the court, Carnival for respondents. I will start with, as the court did...
Can you lower the mic a little bit?
I will start as the court did with service.
Is asking the person in the, whatever you want to call it, apartment SRO, about where the landlord is that enough? Is that a reasonable attempt?
Yes, Your Honor, and fortunately, the Court of Appeals actually resolved this issue for us under Mistecki, which is 30 New York 3rd 239. It's a 2017 case. And the distinction here is that service was effectuated under the city charter. And that allows, or it provides for, I'm sorry, more accurately requires, service for a person authorized to accept service at the premises. And those were the facts in Mistecki. The inspector attempted to serve a notice of violation to a tenant at a residence. The residence stated that she was not authorized to accept service. The inspector then did a fix and mail, and Mistecki said that single attempt to serve, which included knocking on the door for 5 minutes, was sufficient. And that is analogous to what we have here. Just to round out 2 other quick points on service, my friend states that there was a phone number to call the building manager, posted in the lobby. Again, under the city charter, it's irrelevant. The point is service at the premises, which is an immovable property with a registered address with the city. And then secondly, the fact that the superintendent may or may not have been available in the building is again irrelevant. Blanca Realty never represents that the superintendent was authorized to accept service. So what the inspector did here was sufficient under the city charter and under Misteki. Notably, Blanca Realty never denies that it received the mailings or that it saw the notices of violations properly affixed to the door.
Let's talk about the penalty, because it seems kind of like a lot of money, but I guess we have no discretion to lower that. I mean, it's statutory, essentially.
These are the presumptive penalties under the statutes that the hearing officer enforced and which the appeals unit also affirmed. So, but before we get to the...
It has to be like shocking to sense of fairness and for us to overturn that, right?
Absolutely, Your Honor. The standard is shocking to the sense of fairness or unconscionable. But also, let's talk briefly about the purposes behind these penalties. They are encouraging landowners to maintain their properties in comporting with the building code.
And this property was carved up into how many different rooms? 3, right?
There were...
At least 3.
At least, yes, Your Honor. This unit was a legal 2-bedroom, and at least one partition wall had been erected. Unfortunately, some time had passed between when the inspector inspected the unit and when he testified on the stand. But with the aid of photographs, he was able to state, and this credibility was upheld by the hearing officer and the appeals unit, that what remained of the original legal 2-bedroom was 1 bedroom, the eating kitchen, and then the bathroom to which all had access. And then either one of the bedrooms or the living room, he couldn't tell what the designated use of the room was, had been subdivided.
How relevant is it the landlord's position that they were unaware of the subdivisions?
Well, it's the landlord's duty. This was a 40-unit building, and it was the landlord's duty to maintain it within the provisions of the building code. And this is for the safety of all the residents, and it's not just cosmetic. As the tenant stated in her email back to the landlord, one of the doors that was locked was blocking access to the fire escape. So it was not just a subdivision of a unit, but it was actually imperiling the residents of that unit should they have needed access to the fire escape. And if I could just, I guess, just circle back around on the duplicative, the argument that the summons are duplicative. I'll just satisfy any curiosity the court might have with respect to the 3 SROs. So there were 3 individual SROs, hence 3 summonses. With respect to Learned Counsel's point on mailing, the affidavit, there were multiple mailings, and in fact the record beginning at 138 shows all of the mailings, and here it was mailed the day after and was filed. The affidavit of service demonstrating that mailing was that day. So it's an affix and mail, and the affix was obviously on the date of the inspection, which was the 29th of September, 2019, and it was mailed out the next day. And just finally, on the access point, the building, well, that might be a signal for me to stop, unless the courts have any question on the landlord's ability to access the unit.
Thank you, counsel. I think we're all set. Thank you.
Thank you.
Just to briefly address some of the issues. We're not arguing that more than a single reasonable attempt at service has to be made. We're not arguing for anything that's not in line with the Misteki case. Just to be clear, in order for the immediate hazard violation with the increased penalties that come with that, in order for that to be imposed, there need to be 3 additional units in addition to the original unit. There have to be 3 additionals, not 3 in total. It has to be 3 more than the certificate of occupancy allows. And here, that is far from clear. It seems pretty clear here that there were only 2 additional units, not 3. In terms of this issue of whether it was blocking a fire escape, That's not an issue before the court. There was no violation issued for that, and that's not something that should be before the court. With respect to the mailing, again, and the mailing and the filing of the affidavits of service, the affidavit of service has to be filed with ECB within 30 days. It may be true that the affidavit of service, that the original affidavit of service may have been filed on the 29th with ECB, but the affidavits of mailing indicate that the mailing was done on the 31st of December. Therefore, the filing of the affidavit of mailing could not have been filed with ECB.
Counsel, was this something you preserved below, this argument? Did you make it in front of oath?
Your Honor, this is a jurisdictional argument, so whether or not it was made below, the service issue was raised below, the jurisdictional issue was raised below, but it is a jurisdictional issue. So it is before the court, regardless of whether or not the particular issue was raised.
So I take that as a no.
If I remember, yeah, it's a no, yes.
All right, thank you very much,
Thank
counsel.
you
We
all
have your
very much.
brief.
Thank
Thank you both. Mejas v. Linda Bosch. I realize this is an appeal and cross appeal, so if you want to have an additional 2 minutes, you can too. As you like.
If you're willing to give it.
Sure. Anyway, please.
Thank you. May it please the court, Lynn Nolan for the appellate respondent. The lower court denied the defendant's summary judgment motion on this trip and fall accident, citing two bases for denying it. Number one, that the defendant didn't have an expert, and number two, that the defendant didn't address the issue of notice. That's incorrect. There is no requirement that a movement has to have an expert in order to be successful on a motion for summary judgment.
You're agreeing with the plaintiff's expert that it was a 7/8 inch differential. But looking at the pictures, I mean, you don't contest that, do you? Just sort of taking that as a...
I would say initially I agree with that, except when I was looking at the pictures, there's two pictures that show measurements. And I think the one on page 384 of the record, that one doesn't exactly show 7/8. Maybe that one shows 3/4.
Maybe I mistook your brief. I thought you did concede that point. But let's say it is 7/8 of an inch. Also, looking at the pictures, it appears that there's two gradations in the saddle, sort of a wooden base and then a metal top, that both provide places that you could catch your foot or not.
I'd say no.
Okay, but there are the two gradations, though, right? There's a wooden base and then a metal top, or am I
There's
mistaken?
the quarter round,
Yeah.
the flooring, the quarter round, and
Well, there's
then
the tile,
metal.
which is the floor, but then on top of that, isn't there also a little wooden piece and then the metal piece on top for the landing?
Is the wooden piece you're referring to the quarter round?
I guess so. Yeah, I'm not
Yeah.
a builder.
You know,
but yeah.
that neither am I, which is, you know, like,
It appears to be rounded, yes.
so that's the quarter round to, when there's a height differential, that's what's
Okay.
supposed to be used.
But the important point is, and does that, the next part of my question was, would that provide someone an opportunity to catch their toe? I know your client said no one ever catched their toe ever in history of that we've lived there since 1980. But looking at that picture, does that create an issue of tribal fact for a jury?
I don't think so, Your Honor.
How come?
I think that if you take in all of the circumstances, that it's a well-maintained saddle, door saddle threshold that everybody has in their house. And when you look at the measurement that the expert provided, it's so de minimis that the only way you could see that, it's not a glaringly obvious defect. The only way you could see that is if you got down on the ground with a tape measure, and you're talking like fractions of an inch. How could the homeowner ever know that that was something that was a dangerous condition?
Is the law concerning sidewalks apropos, or should we have another standard for a trivial defect in a house.
I don't agree that the law for sidewalks would be the same, because when you're walking on a sidewalk, it's a level ground. That's what you're expecting. When you're walking out a door, especially the door that's involved in this case, there's a step down. She knew that there was a step down. So when you're walking out a door, especially with a step down, you know when you're changing from one room or leaving a house or wherever it may be, that there is going to be a change in elevation. You should expect that.
The step down doesn't happen right away. There's a landing, right? Looking at the photos.
There's one step to a landing,
Yeah.
and then the landing is one step to the walkway. And so, any other questions on that? Or?
No, I don't have about that, no. Anybody else? You have time in rebuttal as well.
Okay,
I mean, please, if you have another point you want to amplify, go ahead.
You know, just I was going to say that the lower court also said that we didn't address notice, but we did address notice because actual notice was satisfied by the testimony of the defendant and the non-party witness, her husband, that said never any complaints about this door saddle. They've lived there since the 1980s.
Oh, so you got a problem on constructive notice, though.
I was going to get to that, but I'll get to that on
You can do that in
rebuttal, or
rebuttal.
would you like me to answer that now?
Please, actually, why don't you go ahead?
On constructive notice, it has to be visible and apparent. And like I did state before, it's clearly not visible and apparent when you have to get down with a tape measure and see just these little fractions of an inch. Clearly not visible and apparent danger.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. John Reddy on behalf of plaintiff, respondent, appellant. This court should affirm the decision as to the denial of defendant's summary judgment motion, but vacate and direct the court to grant plaintiff's summary judgment
On
motion.
what basis? What factual questions have all been resolved that the plaintiff is entitled to summary judgment?
There is no evidence that defendants have put forth against the fact that a 7/8 height differential is defective. That's the first matter.
Would we be the first appellate court to say that a 7/8 inch differential is, as a matter of law, a defective or hazardous condition?
I don't think you need to say that it as a matter of law, this number reaches that. I think you could rely on simply the burdens on a summary judgment motion where a plaintiff has an expert talking about longstanding practices as it relate to thresholds, whereas defendant has no contrary evidence. Perhaps if defendants had some sort of expert or some sort of law they could cite to, it might be a question. And so I don't think you have to make it a matter of law.
Well, it's summary judgment, so.
Well, yes, but it's the defendant's burden to raise a triable issue.
So what other than the differential supports a finding that it's a dangerous or hazardous condition?
The height is the differential. I'm sorry if I misunderstand you.
Right, so it's not a matter of the lighting or anything like that.
No.
It's just the differential.
So why wouldn't that be a finding as a matter of law that a 7/8 inch differential is in itself a non-trivial defect?
What I'm saying is that the court does not have to make a precedential ruling that 7/8 inches always.
But the ruling that you're asking us to make is that precedential ruling.
In the face of no evidence from the defendant. If the defendant doesn't support its argument that 7/8 is not defective, then you can only look at the evidence in the record, which goes to the plaintiff's expert's vision of longstanding practice.
But so it is the one element or factor, if you will, is the differential. It's not that this presents some sort of trap or snare. It's not that there's, as Justice Moulton just indicated, that there's some problem with the illumination in the area around. It's not optical confusion. It is the height differential here unrebutted by the defendant.
Yes, that's exactly my point. And so that's the first prong in the inquiry. You asked how can we grant summary judgment? Well, then you go to the next prong about notice, and it's not just notice, it's not just constructive notice, but it's also creation of the hazard. And I haven't heard any argument as to why replacing flooring.
Yeah, but that's a tough one for you to prove because the tile or the linoleum was replaced by tile. We don't know how high the linoleum was in relation to the saddle, especially and compared to the tile. So, how do we know that there was some that exacerbated somehow the differential.
I don't think it needs to have exacerbated it. It could have made it less, it could have made it the same, it could have made it worse, but it's still a defect. 7/8 of an inch still violates every sort of law and custom in the record concerning the height of thresholds. It doesn't matter what it was before. The defendant had a choice as to what level it could have put the floor so as to lower what the differential was, i.e. bring it under compliance within a half an inch. But the defendant, by choosing tile and in the manner that it was installed, did not.
When you say bring it into compliance, what codes are you relying on?
Well, so in this case, the only evidence in the record concerns is the expert's assessment of longstanding practice. Defendant hasn't, I see my time is ended. Can I answer your question?
Please, please.
Defendants might argue that the 1930s building code or 60s building codes did not specify any sort of height requirement as to threshold. But that should not be understood as blessing any sort of threshold, right? A threshold that's a foot high would be kind of ridiculous and doesn't really apply. So it requires you to look at some other standard. And the only standard that we can point to is what the expert says, who has 60 years of experience and 5,000 inspections. And he supplements his opinion by pointing to law as it is now, which reflects what it was back then. And you could look at the ADA, the Fair Housing Act, the International Building Code, the various things that he looked at to determine that this is how it's always been. And his opinion is unrebutted.
If there are no further questions. You have time to rebuttal.
Thank you. What I'd like to just point out is, going along with all of your questions about that 7/8 height differential, it's well established that height alone, a mere measurement alone, is not enough to satisfy the burden or to find a defective condition. The court has to examine the width, the depth, the elevation, the irregularity, the appearance. Does it look like a trap, a snare, a danger is glaringly obvious? Absolutely not in this case. Then the other point I would like to make about the plaintiff's expert is they consistently talk about the height differential, 7/8, 7/8, 7/8, and all the statutory violations. He says that the defendant was negligent because they violated a statute. There is absolutely no statute that applies to this home, and there is absolutely nothing that says the statutes, the New York City building codes now should be applied retroactively.
What I understood your opponent to say is just simply he was being informed by those various regulations, but not that they applied particularly to this home. That's what I understood.
Yeah, but how does that go into play, that if you now apply current statutes, you're applying them retroactively, and that's just not the way it should be. It's not the way it can be. I don't have anything else if anybody has any questions.
Thank you, counsel.
I appreciate your time.
Two very quick points. I agree that height alone is not enough, but under the circumstances, when you look at Hutchinson, the Court of Appeals case, direction to look at, to examine situations where pedestrians would be expected to look ahead.
It's pedestrians on a public walkway though, right? This isn't a private residence. So are the considerations any different?
Hutchinson literally says at premises, exits, and entrances.
Okay.
So in my view, that applies here.
So what is the strongest precedent you have from our court or another to support summary judgment in your favor? The closest case in your view?
I can give you two, but pieces of each one. So I would say that the case of Teneo, which is the First Circuit case cited in the brief, concerns a height differential of 3/4 of an inch, which this court found sufficient to grant summary judgment in plaintiff's favor. And then with respect to the creation of the hazard/notice issue, I would point to the First Department's case in Dan, which was it was a school dean who got injured at her school's entrance. With respect to creation of the hazard, I would point you to the First Department's case in Rondon.
Rondon was post-trial though, right?
Yes, but I think the principles of law that it established applies here in the face of no evidence from no affirmative evidence from the defendant. The only last thing I want to say is that for the reasons expressed in my brief, the lower court's rejection of the expert's opinion was flawed. Thank you.
Okay, thank you. Thank you both. City of New York v. Eisner. Okay, counsel, thank you.
Good afternoon, may it please the court. Chase Mechanic for the respondent, City of New York. I'm mindful that my adversary is not here, so I'll aim to be brief while answering any questions the court may have. The city demonstrated its entitlement to an order turning over the funds in Ms. Eisner's bank account. Ms. Eisner owes the city hundreds of thousands of dollars in unpaid ECB judgments, making the city her judgment creditor. Her only opposition to the petition was a pro se answer that was conclusory, raised defenses that she's abandoned on appeal, and as Supreme Court held, failed to adequately controvert the city's petition. With that, I'm happy to answer any questions the court has.
I think we're good, counsel.
We ask the
Thank
court
you.
to affirm. Thank you.
Pacheco v. Catholic Guardian Services. Please.
Thank you, Your Honors. May it please the court, Robert Tucker for Appellant Catholic Guardian Services. This appeal asks whether the respondent and the putative class members can state a cause of action for hourly or straight pay for hours worked beyond their scheduled hours, even though they are all salaried exempt employees who are exempt from overtime. The respondent's novel theory that the putative class members are entitled to compensation beyond their salaries has no basis in law or fact. First, the New York labor law does not provide a basis for recovery under these circumstances, meaning where the employees at issue have received the minimum wage and are not entitled to and exempt from overtime. Section 191 of the New York labor law, which is cited in the complaint, addresses the frequency at which payments are made. It does not address unpaid wages.
And Section 198 only deals with remedies, correct?
That's correct, Your Honor. The second issue is that respondent has not cited to any authority supporting the proposition that salaried exempt employees are entitled to hourly compensation in excess of their regularly scheduled hours. It is not enough for the respondent to say, as she has alleged, that she and the putative class members received a salary, worked beyond their regular hours, and then didn't receive additional compensation. There needs to be something more. There needs to be an agreement. And there's no allegation suggesting that either the respondent or the putative class members agreed with the appellant here that they would receive additional wages if they performed additional work. So without that, respondent has two problems. First, this issue of there's no legal remedy or there's no recourse to her under the labor law. And second, even if there was for some sort of just general unpaid wage claim, she doesn't have any basis, right, in the sense of any sort of legal entitlement or any agreement that would entitle her to get the wages that she believes she's
What about
owed.
her claim that she was working as a non-exempt clerical worker?
That is the claim, Your Honor, but the lower court found that the respondent and the other employees, these putative class members, were exempt from overtime. So, and that brings me to respondent's brief, which I think reveals that this remaining cause of action is really just a disguised claim for overtime, or it's, if not disguised, it's a derivative of that claim. It's essentially
Which was already
saying,
rejected by the court below.
correct, Your Honor. And so we would even argue that the fact that plaintiff's theory here, and as stated in her brief, that these employees were misclassified lends support to our argument, which is if somebody's misclassified, you're saying they were paid on a salary basis, there was an understanding they weren't going to get overtime, but they should have gotten it. The court has said that's incorrect. But if that's the case, if that's the factual understanding, then that means there wasn't an agreement that you'd get additional hourly compensation. The understanding in the agreement was all you would get would be your salary. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Andrew Jordan for Plaintiff Ingrid Pacheco. Our position is that the lower court never made a determination that plaintiff was a exempt employee. While defendant may be exempt due to the certification from paying an overtime rate of pay and overtime wage, that does not mean that plaintiff does not have to be paid for all time worked. Plaintiff's salary was for 35 hours.
Isn't that by definition overtime? I mean, if she's being paid for work outside more than the hours she agreed to work, I don't understand why that's not the same as overtime.
So, Your Honor, plaintiff's salary is to cover 35 hours in a week. Overtime would start after 40. Plaintiff's contention is that she worked between 40 and 45 hours on a regular basis. So she was not compensated for hours 35 to 40.
But that's overtime, right? Based on the definition that you just provided here, or the explanation you just gave us.
No, that would be at a straight time rate, Your Honor.
Oh, okay, maybe my math is off.
And
What provision of the labor law are you relying on? How does labor law section 191 cover this case?
we feel that 191 and 198 covered because plaintiff has a right to be paid for time worked. If a
But
company...
191 has to do with untimely payments, not for unpaid wages.
Well, in our position, the wages are not paid timely because she is still owed those to this day. The wages, she was not paid for all time worked. So she has still
But
not
it's for
timely been paid.
So
So she was not paid in a timely manner because there were hours that she worked that she has not been compensated for.
So that makes it untimely versus unpaid?
It was unpaid, and by being unpaid, it made it untimely. And if I just may, to be a exempt employee...
How is that different from a claim for overtime?
Because we're asking the plaintiff be paid, again, at a straight time rate instead of an overtime rate.
So you said she agreed to work 35 hours?
35 hours, Your Honor,
And
yes.
she regularly worked how many hours?
40 to 45, Your Honor.
So she's looking to be paid for the time from the 40 to 45?
From 35 to 45.
So
And
she was scheduled to work 35 hours?
yes, Your Honor.
But
That was what the
more
salary
than
was.
45 hours, right?
She worked more than 35 hours, yes.
So then that becomes overtime.
No, Your Honor, it would be paid at a straight time rate. Overtime, by
But
law,
she was a
doesn't have to
salaried
be.
worker, right?
But that doesn't mean that she's exempt. In our brief, we discuss how there are duties that you have to be able to do in order to be an exempt employee. Otherwise, it would not stop an employer from classifying everybody as an exempt employee, working them as many hours as they wanted to, and paying them whatever they wanted to, and never having to pay overtime.
But that's not the situation here. The situation here is that she's exempt because she works for a non-for-profit.
She's exempt from being paid an overtime rate of pay and for overtime. But again, Your Honor, overtime starts after 40 hours. Are there any other questions?
Thank you, counsel.
I just want to cover a couple of
Could
things.
you address that, whether the exemption for not-for-profits means that they could still be liable for straight time in excess of the number of hours that the person was otherwise required to work?
They could, Your Honor, if they were paid on an hourly basis, right? Because you could have an employee who's paid on an hourly basis, who's exempt from overtime under this not-for-profit exemption, and then that person would be entitled to compensation for all hours worked. So if, for instance, they were only paid for 35, but they worked 45, they'd be entitled to recover 10 additional hours. Now, I might argue that you couldn't do that under the labor law, but that's a separate issue. The issue here, though, that the respondent can't confront and can't get away from is that she was paid on a salary basis, and all these folks were paid on a salary basis. So the understanding was the salary is going to cover all the hours they're working. One last point. There was an assertion that the plaintiff's salary was to cover 35 hours, but that's not alleged in the complaint. And that's something we pointed out in the briefing below, and despite opportunities to amend the pleading to include that allegation, that's like a conclusion. There's no factual allegation suggesting that the employer said, hey, here's your salary. It's for just 35 hours a week. If they had done that, it also begs the question, what's the straight time rate? Like, how is this additional pay, how is it calculated? How is it determined? All these questions are unanswered and really reveals the fact that there was no understanding, and that once these individuals are deemed exempt, there's nothing left for them to recover in court.
Thank you, counsel. Thank you both.
Thank you.
Canales-Diaz versus the City of New York.
Good afternoon, James Walsh on behalf of the appellants. May it please the court. We are here today to argue that the order of the court below denying the motion to vacate the default was an abuse of discretion. And what the judge found in the court below was that there was no substantiated evidence of a medical emergency.
Yeah, the plaintiffs didn't contest that Ms. Cower, the lawyer, had a family emergency, right? They didn't really contest that below.
That's my understanding, and having read the record, yes.
So that was brought up more by the court?
Yes, because from my understanding of the file, had that been raised, additional evidence would have been put forth. I think there's two issues here. You have someone who is probably not at liberty to freely include in her motion papers issues about her father's medical condition. I think that's number one. And number two, as you just mentioned, it was not challenged below, so there was no reason to put additional evidence of plane tickets and things like that. And had the court inquired about that, it would have been provided.
Perhaps you could turn to the issue of the merits.
Sure. On the merits, a signed sworn statement of someone who arrived immediately after this accident was provided with the motion to vacate. And that person says they went over right after the accident happened and saw Mr. Canales-Diaz lying on the ground. And the claim being put forth in this case is that Mr. Canales-Diaz fell because the ladder moved. And he says he checked the ladder, and the ladder was solidly clamped down. It was not moving. And it was
clamped to the scaffold, but was it clamped? Did the photo show that it was clamped to the bottom of the scaffold?
I've looked at that photo quite a bit. I can't tell one way or the other, and I just don't see anything one way or the other. It's a very small photograph.
Was the ladder tall enough to reach the top of the scaffold?
Well, similarly, there's no evidence that it's too short. Counsel says that over and over in his papers. He does not have a record citation for that. There's no evidence of that one way or the other. And if you look at the argument they put forth, it's on page 64 of the record in the motion below, counsel said the reason this accident happened is that the ladder moved, not that it was too short. And Mr. Canales-Diaz also testified similarly that the reason he fell, and he said logically, it's because the ladder moved. He didn't say it was too short. They have to show proximate causation from anything that they've raised. And they just don't have evidence that this was too short. And even if they did, it's not the proximate cause of what happened here. He very clearly says the ladder moved and that's why I fell. And that's what they argued in their motion. Page 64 of the record, counsel says the reason this happened is that the ladder moved. So that's our argument here, and we believe that clearly creates a triable issue of fact on all of the labor law issues, on 240 and 241-6 on the industrial codes that they rely upon.
Thank you, counsel.
No further questions. Thank you.
Good afternoon, Your Honors. May it please the court. Jesse Mink for the plaintiff's respondents, the Canales-Diaz family. To address the merits, because as the court and Mr. Walsh pointed out, I tried to be as polite as I could. In acknowledging that Ms. Cower had an emergency. What I don't agree with, and what I think is clear in what I argue, is her boss, Mr. Ross, did not have such an emergency. I did reach out to them. I was ignored, and this default was entered. Also, Ms. Cower made no effort whatsoever after she got back to the office to address this issue. But that's not really why I think, I would prefer that this be decided on the merits. And under Felker against Corning, which is a Court of Appeals case from, I believe it's 1997, it's cited in my brief, they were obligated to provide a safety device under Labor Law 240 for every risk to which Mr. Canales-Diaz's work exposed him that has a gravity-related implication. There were multiple. Obviously, if Mr. Nijar's affirmation is accepted as true, which we go into reasons why it's not sufficient even to raise a question of fact, the Priestley case cited is a post-accident inspection that doesn't really constitute any kind of an inspection, is not sufficient to raise a question of fact. But let's accept that Mr. Nijar did actually inspect the ladder sufficiently to at least raise a question of fact. Placement, which is stated in 240, has to be operated, placed, and provided. Placed is specifically in the statute. Mr. Canales-Diaz testified that he's working on a bricklayer scaffold. He's a bricklayer. This thing is up about 10 feet off of the main scaffold deck. It's a piece of a scaffold that can be adjusted. It's called a bicycle, that is the bracket it sits on, and then there's a plank. To get to this ladder, he had to climb across a windowsill. He had to do so while holding on to the scaffold cross members. There was no safety device to protect him from falling through the gap while he was doing that, which is exactly what happened. The ladder was totally insufficiently placed, and proximate cause this goes back to Zimmer against Chemung from 1985. There was no device provided to protect him from the risk of falling through the gap while he was doing that. And as to proximate cause of the placement, he said he had to do acrobatics to get his foot on the top of the ladder and that he felt it move, even if under Blake, which is this the Court of Appeals case from 2003, if a ladder malfunctions for no apparent reason, that establishes a prima facie case. That's exactly what Mr. Canales-Diaz's testimony does. They have criticized our expert, Walter Conan, as speculating, well, experts connect the dots. And that's exactly what Mr. Conan did. He took Mr. Canales-Diaz's testimony and he said, okay, so you've got several violations. Most importantly, we would rely on the placement issue. There was no safety device provided that was sufficient to allow him to cross that gap safely. There's no dispute in the record that he fell a distance of about 8 or 10 feet. And we think that this court should affirm on the merits, if not affirming on the fact that the lower court didn't abuse its discretion. This court would have to find that Judge Danziger abused his discretion, that he didn't follow this court's clear directive in the matter of Amira Nicole, Tamika R. 73, 83rd, 428. This court said in 2010, unsubstantiated claims or excuses should be summarily rejected. And he followed this court's directive in that respect. It's their burden to demonstrate a reasonable excuse. They didn't do that. He didn't abuse his discretion in making that decision, but ultimately, whether or not there was a reasonable excuse on the merits, the plaintiffs were entitled to Labor Law 240 summary judgment, and this court should affirm on that basis. Thank you very much.
Thank you, counsel.
Very quickly to a couple of points I would like to say. With regard to his argument about a communication to Mr. Ross, that's nowhere in the court below, right? What he said is, I personally reach out to the firm to offer an extension, and I received no response to this communication. Doesn't say what it was a telephone call, was it an email, was it anything? Now suddenly we have a lot of details about that. And sticking with that issue for one brief minute, the finding of the court below was that It was completely unsubstantiated, the medical emergency. You just heard that counsel doesn't dispute it, and we have an affirmation, a very detailed affirmation from counsel going through what she went through. That's substantiation, and we think, as Judge Higgett, Justice
So if you
Higgett
can't
said,
overcome the merits issue, then that doesn't really matter, does it?
well, on the merits issue, I'd like to go back to that. And what Mr. Canales-Diaz testified at deposition, and he's the sole witness here as to what happened. To the best of your knowledge, what caused you to fall from the ladder? What caused my fall? Yes. Logically, it was the fact that the ladder wasn't properly fixed. That would be the logical answer, not properly fixed the way it should be by law. Record 384. Nothing about the height of the ladder, nothing about the placement of the ladder, only that it moved. That's what this case is about, and that's what they argued in the court below.
Thank you, counsel. Thank you both.
Thank you.
Finally, Thomas v. Concourse.
Good afternoon, Your Honors.
Afternoon.
May it please the court, Scott Horn, counsel representing the plaintiff appellant in this matter. It's our contention, Your Honor, that the motion court erred in awarding 3211A7 pre-discovery dismissal based upon the defendant's affirmative defense of EDTPA immunity.
Counsel, before we get to EDTPA, I'd like to talk about your complaint.
Okay?
It seems to me that in your complaint, apart from the first paragraph, you allege over and over that decedent was treated by defendant from the period from February of 2009 until her death in April of 2020, which is different from what you say in the first paragraph. And all of the allegations that you make about inadequate treatment have to do with the period from January of 2009 until April 20th, April of 2020.
Yeah, you say she died twice on April 9th, 2020, which is not correct. I know you're appellate counsel. I understand you didn't draft the complaint, but the
Yes, Your Honor.
complaint is really a disaster. It has a lot of it has wrong information. It's poorly drafted. Anyway, so.
I don't dispute that.
And that's a problem because there's a disconnect here. The complaint alleged that she died because of COVID, gives different dates for her death. And then so the defendant comes in and says, okay, EDTPA, we're going to argue that.
Right.
And now all of a sudden it turns out she did not die from COVID. Or actually, counsel, tell me, what was the cause of death?
Well, according to the complaint, the cause of death was connected to COVID. So that's at page
No, we're not asking. Okay, go ahead.
Go ahead, counsel.
R12 in the record. So this is a pleading. It's a motion to dismiss under 3211A7. It's based upon evidentiary materials. And so the burden, obviously a substantial burden, as evidence from this court's decisions in Holder and Jackson, rests with the defendant. I agree with you.
But do you agree that the only wrongdoing you allege by defendants occurred between February of 2009 and April of 2020, and that's it?
That's all I see in the complaint, Your Honor. So the wrongdoing in the complaint is pegged to the time period when she contracted COVID.
But still, somehow she died of COVID, or because of how is that unpacked in the complaint?
I'm not an expert. Our expert didn't render an opinion on that.
It's a motion to dismiss. I understand. I'm just asking what the allegations are. I know it's a motion.
I can only go based upon what the allegation is.
And what was the allegation?
The allegation was that she died of a COVID infection on March 31st, 2021, which is at page R12 of the record. But ultimately, I think that the date of death is really only impacts the issue of whether or not they met their burden to establish that they rendered healthcare services after the amendment of the statute on August 3rd, 2020. The fact that she alleges that she was impacted or contracted COVID as a consequence of the defendant's actions merely sets the table for what they're required to show in their motion pursuant to 3211A7 based upon evidentiary material. So I respectfully submit today, and what I came here to argue is that based upon Holder and Jackson, the fact that there has been absolutely no discovery here leads inexorably to the conclusion that this motion is premature. As in Jackson, there's a request for accelerated judgment in the context of what's supposed to be a fact-sensitive inquiry. Also, as in Holder and Jackson, defendant's motion is predicated on information that is singularly within its own knowledge. And it places both the plaintiff and indeed the courts in the position of having to take defendant's word on dispositive issues based upon an affidavit and other evidentiary submissions that pale in comparison to Holder and Jackson.
So you want us to apply Jackson, Holder, and the immunity statute generally to the allegations that are in your complaint?
I think that that's accurate, yes.
Okay, we're not looking beyond, as Justice Gessmer just mentioned, we're not looking beyond sort of April of 2020 vis-a-vis the allegations of negligence.
As far as I can discern from this complaint and the expert affirmation that was submitted in opposition, that is where the allegations of negligence arise, although causally it could very well have connected to her death 11 months later. I see that my red light's on. If I could just finish this one point, and that is, there is no evidence on this causal connection. The only statement that the defendant offers is from the nurse in the nurse's affidavit, and it's unsupported by any medical evidence whatsoever. So there is no evidence either way on that issue of causation, and I would respectfully submit that it would be an improper issue for this court to determine as a matter of law on the state of this record based upon this 3211A7 motion. If there are no further questions, I'll wait on my rebuttal. Thank you.
Good afternoon, Your Honors. My name is Lisa Fleischman. I represent the respondent concourse. Jean-Claude Laborde is the director of nursing who provided an affidavit, who personally also cared for the decedent. In his affidavit, he states upon his review of the record that the decedent did not die from COVID. I believe that's at page 108. I was trying to verify.
So in that case, why even make a defense based on EDTPA? That's the disconnect I don't understand here. Why not just say, they say she died of COVID, but she didn't die of COVID, she died of renal failure or something else?
Right, we asserted the defense because the complaint claimed that the decedent died in April 2020 from COVID.
It did say that.
It does say that. It says it multiple occasions, 6 or 7 times throughout. Only on the first page of the complaint does it state the actual correct date of death, which is March 31st, 2021.
No, and on the motion practice below, didn't plaintiff's counsel also say something along the lines that she died in April 2020? I think she said in her affirmation, untimely death due to the accident of emissions, yeah.
That's correct, Your Honor. In her opposition paper, she did say that the injury death was April 9, 2020.
So based on the allegations, that's the reason why you raised this affirmative defense, essentially?
Yes.
But in doing so, do we have were there enough facts in the record to establish the affirmative defense, and is that something that should be determined on a pre-answer motion to dismiss?
Yes and yes. The affidavit from Mr. Laborde establishes that the response to the pandemic that concourse had to undertake under federal and state guidelines directly affected the decedent's care. She couldn't once she was diagnosed with COVID, she couldn't get her outpatient dialysis care because the provider refused to provide it. She was isolated initially when she was diagnosed, and then she was clustered. Her medications had to be reviewed for essentiality because of the guidance that had been issued that concourse was required to abide by. She required a psychiatric consult because she was feeling sad and upset at the isolation caused by her COVID condition. She had to get physical therapy because of her extended rest. Her quadriceps had tightened up, and she could only have the PT at bedside because
But the
of
allegations of negligence are, as I understood them from the complaint, basically a failure to prevent her from contracting COVID, right?
Right.
Okay. So could you orient your discussion about the immunity, the alleged applicability of the immunity statute to those allegations?
Sure, Your Honor. As Mr. Laborde sets forth in his affidavit, Concourse implemented pre-pandemic policies and testing procedures, all in accordance with state and federal guidance, all designed to try to prevent the spread of COVID. And with respect to Ms. Spigner specifically, she was given Tamiflu prophylactically, and they did what they could to keep her from getting it. So we not just have the systemic changes that were made as a result of the pandemic, but also the way that the decedent was treated by Concourse specifically, directly. And I submit to you that all of that demonstrates the impact that was had on her care and supports the
And her
dismissal.
care, at least with respect to COVID, was successful, right? I mean, Mr. Laborde, it is Jean-Michel, he's a man, right?
Yes, he is.
He says that she was essentially free of COVID by August of 2020?
She was free of COVID by May of 2020. Her temperature never went above 99
But they,
degrees.
okay, sorry.
Yeah, I'm sorry.
They continued to monitor her, and COVID didn't come back, right? So they successfully treated her for COVID.
They successfully treated her. On pages 102 through 108 of the record, you can see the breakdown of all of the efforts that were made to treat her. And
does the complaint talk about or try to isolate somehow the pain and suffering she incurred as a result of contracting COVID, which she got better from? It doesn't, right?
No.
There's a wrongful death claim here. It says several times in the complaint she died because of COVID, right?
That's what she said. Yes, the complaint is wrong. She did not die from COVID. She had a mild case of COVID. There's discussion of pre-pandemic history of lack of infection controls. That's wrong. We disproved that with surveys from CMS showing that there was a single violation in July of 2019, and that was remedied. There was no history of pre-pandemic.
See, that's a motion for summary judgment question, though. That's not a motion to dismiss. They make their allegations. You're trying to approve, what you were trying to do was to prove an affirmative defense of immunity. And you did that, or you tried to do that.
Yeah, I submit that we did. Your Honor, may I just speak for another?
Sure, and Justice Gesmer has a question as
Oh,
well.
I'm sorry, go ahead.
So now that counsel has conceded that his complaint only alleges that defendants acted wrongfully between 2009 and April 9th of 2020, and given that the ETDPA wasn't effective until March, the ETDPA is only relevant for 1 month of her treatment, right?
I would submit it was relevant for the time that she had COVID.
Right, but it was only a 1 month period that the statute was in effect and that their allegations extend to.
Correct, Your Honor. And the argument that
So this whole motion only concerns from early March to early April of 2020.
Yes, by virtue of the fact that the plaintiff pleaded injury and death ending on April 2020. Just with respect to the pre-pandemic history, that goes to the gross negligence claim, and this court has rejected the idea that that type of history constitutes gross negligence. If Your Honors have no further questions.
Thank you.
Okay, thank you so much.
Very briefly, Your Honor, I cannot defend what's in the summons and complaint, but I do not want anyone to overstate what's in the summons and complaint. And Counselor just said that 6 or 7 times it mentioned that the date of death was 4/9/20. That's not what I see, and I've been through the complaint several times.
That's in the complaint several times.
I see 2 times. on pages 18 and 23.
The 2021 date of death is only in paragraph 1.
Correct.
And everything in the complaint after that says at all relevant times in this complaint here and after. So they were never referring to what you said in what was said in paragraph 1. It always referred to what came later, which was the alleged date of death of April 2020.
Right, so I see one reference to a date of death of
Okay,
March 31st, 2021, and then I see two references. to
Exactly, but your complaint alleges that defendants acted wrongfully at all dates here and after. And here and after referred to after paragraph 1, which is the only place where they alleged the 2021 date of death.
Okay, I understand what you're saying, Your Honor. So, but the point is that there's one reference to 2021, two references to 2020. It's confusing, and I can't defend it, but I don't want it to be overstated either. The second point that I'd like to make is that the Laborde affidavit makes the statement, her COVID infection 11 months earlier was not causally related to her death, but there's no support whatsoever offered for that. He just
Well,
goes
except
out
for
and
the,
say
he
it.
does prefatory say, you know, I reviewed her medical records. He does say that in his affidavit.
Yes, Your Honor. But again, being a 3211A7 motion based upon evidentiary material, we submit that that would not be an issue that lends itself to being resolved, just like the EDTP
and also
immunity.
they didn't move on that ground. They moved on the immunity ground. It wasn't
Correct.
that.
I mean, at the end of the day, that's all they moved on was the immunity, and that there are, I see that my time is up, if I can just answer that.
Please.
And as a consequence of the fact that they moved on the immunity only, we respectfully submit that this adjudication should be governed by Holder, by Jackson, and the prematurity analysis that's evident in both of those cases. These issues should be resolved after discovery and after we can all get to the bottom of what's stated in the summons and complaint. Thank you, Your Honor.
Thank you, counsel. Thank you both. No, I'm sorry, counsel. There's no rebuttal. Thank you.